but he is under bereavement, my lord. I pray for 1 week time, my lord. And municipality has filed affidavit, that is also.
You have filed the affidavit.
Municipality has filed, my lord.
What do you want?
I am for responder 5, affidavit is ready, my lord. The whole person is, my lord, under bereavement. So,
Ask your junior to mention this matter when the matter is.
May I please, Lordship? Proceeding item number 6, Lordship. On last occasion, Lordship was pleased to allow us to file an additional affidavit, Lordship. So with additional affidavit has been filed, Lordship, the records may be called for, Lordship. Records may be called for, Lordship. Of life.
may I please, my lord, item number 44, my lord, contempt order, my lord. Matter has been complied, my lord.
Yeah?
Matter order has been complied, my lord.
Item number 44.
Procedural, my lord.
Mr. A.H.M.R. Chaudhary, the learned counsel appearing on behalf of the petitioner, submits that the order dated
Order dated 13/10/2023.
past in
WPC 5766.
have been duly complied with. He therefore submits that the petitioner would therefore would not like to further proceed with the instant contempt proceedings. Taking into account that the order passed by this court have been duly complied with, the contempt proceedings stands dropped. Yes, madam.
I beg to mention item number 39, my lord. My lord, I may be allowed to withdraw this petition. My lord, I have been instructed by the petitioners.
Ms. S.B. Chaudhary, the learned counsel appearing on behalf of the petitioner, submits that she has instructions to withdraw the instant petition. Accordingly, the petition stands closed on withdrawal. Interim order, if any, stands vacated.
This one, to do. Right, this one. I will to mention item number 45, my lord. I want to withdraw this on being instructed.
Huh?
Infractious, man.
Your name?
PK Mohindra, my lord.
Mr. P.K. Majumdar, the learned counsel appearing on behalf of the petitioner, submits that the petition has become infractious, and as such, he would like to withdraw the instant petition. Accordingly, the petition stands closed on withdrawal. Interim order, if any, stands vacated.
Last one.
Please, your lordship. Lordship, I recommend item 25. I have the instruction to withdraw this
Name?
MK Chaudhary.
Your name?
My name is MK Chaudhary.
M.K. Chaudhary. See, I got order to Mr.
Okay.
25.
May I please, your lordship? I like to mention for listening of a case for admission purpose.
Why?
Victim compensation case. It is pending since 2022.
No, we'll have it.
Next.
कौन 16 नहीं है? 27 September.
Okay.
कौन 16 नहीं?
May I please, lordship? Lordship, I beg to mention item number 17, lordship.
7?
17, lord.
Yes.
17, because we like to withdraw our wakalatnama, lordship.
What wakalatnama? You can't withdraw your wakalatnama in this matter.
Because lordship, our name may be strike down from.
No. File your affidavit. Why?
Lordship, we are trying to contact our client, lordship.
Huh?
We are trying to contact our client.
So, your
No,
responsibility with your client remains. Filing a writ petition out here does not make it absolve you, and tomorrow you say that I am no longer there. Your responsibility remains till the matter is taken away or the file is taken away from you.
Lordship.
So your responsibility remains. So you have to argue the matter.
Lordship.
May I please, your lordship? Have we filed a stay vacate petition, lordship?
Huh?
We have filed a stay vacate petition, lordship. There is some urgency. Any day to convenient to your lordship.
It's an order passed by,
Right, please, sir.
no, it's okay, but it is an order passed by ex parte.
Yes, lordship. On that day, we were not there. We have received notice.
When did you file it?
Friday, lordship. Friday, last Friday.
We take it up on 2020.
No. Deep blue.
Lordship, my grievance has been redressed. Now I want to withdraw the case.
Huh?
My grievance has been redressed by the
Your grievance?
has been redressed.
Okay. একটু withdraw করিব, নাম তো লইব।
Obliged.
Interim order if any minutes.
May I please, your lordship? Because in this matter, I pray for some time because the petitioner, mother is suffering from cancer, so the compromise could not be arrived at,
What compromise?
The settlement,
What gentleman? Between,
whether any settlement can be done in the case or not.
between whom?
Between me and the company, between me and the company,
What are you challenging here?
Because in this case, taking cognizance of the complaint proceeding by a court of Calcutta.
Oh,
Yes.
that matter.
Yes.
I'm not extending the interim order. I have not extended the interim order. Okay.
On Friday, because on the basis of which this, in this case, notice was issued, that has been fixed tomorrow, Milord.
No, nothing doing. You have no business out there unless you show. Show me something to show this is that you can file a case. You can challenge by way of a 226 or 227 before this.
Yes.
In respect to a proceedings pending before that court.
Yes, Milord.
Yes, what does it say?
103, paragraph 103, Milord. First, paragraph 1, may I read, Milord?
Yes.
Reiterating his earlier view in so and so, wherein he has given certain category of cases in which an order of the magistrate issuing process against the accused can be quashed or set aside, on further stating that the same principle laid down in the decision would apply mutus mutandis to a criminal complaint also. So this is one aspect, my lord. Now, my lord, kindly come to paragraph 108. In the backdrop of the interpretation of the various relevant provisions of the code under chapter 14 and of the principles of law enunciated by this court in a series of decisions relating to the exercise of extraordinary power under Article 226 or inherent power under Section 482 of the code, which we have extracted and reproduced above, we give the following category of cases by way of illustration wherein such power could be exercised either to prevent abuse of process of any court or otherwise to secure the ends of justice, though it not may be possible to such.
These are not the answer.
226 is the answer.
226 power I can exercise, no doubt. But why should I exercise in respect of proceeding which is under the jurisdiction of the Calcutta High Court? That is my issue.
Applying the principle provision provided under 226
Better you take up this issue before the Supreme Court again.
226
Nothing. 226(3) does not, 2 does not come into the picture here. Here you are aggrieved by the initiate, not the on the basis of filing of a complaint. You are aggrieved by the issuance of process by a court.
Yes, taking cognizance.
Understood.
Below.
The process has been issued out there by that court, which is under the jurisdiction of the Calcutta High Court. Why should this court initiate? Nothing doing here. This court has no jurisdiction.
Because
And in fact, this court should not.
paragraph 108 speaks about
Paragraph 108 is in respect to no case being made out. Very well. This is on the basis of Bhajanlal. There is nothing new on that. 226 jurisdiction can be initiated. There is no quarrel with that. But you are aggrieved by issuance of a process by that court. So this court has no business out there. In fact, there is many judgments also on that aspect. Majithia case is the only judgment on which, but that was not against the complaint. That was an FIR filed out there in Shillong. And on the basis of the FIR, there was a direction passed by the High Court for making an investigation, forming a team by the Guwahati High Court. Then this went out there. Then he challenged out there in Bombay. Bombay High Court said nothing doing. Then thereafter, matter went to Supreme Court. Supreme Court that said that entire transaction happened out there against an FIR very well, because it is another aspect to the matter. But here the cause of action is the issuance of process. Your basic case is 202 has not been followed. How will this court start exercising such jurisdiction?
that apart from for reading of the complaint itself, 207.
Whatever may be,
Court
this
will
court has no business out there. Your basic thing is you are asking for that particular thing to be quashed, the issuance of process. Otherwise, you are not aggrieved to go there before the Calcutta High. Otherwise, it will be opening up floodgates out here.
Not here. Jurisdiction of two court is involved, my lord. One is that trial court and one
The
is
jurisdiction
of this honorable,
no,
honorable court, my lord.
no, not this court. It will be the Calcutta High Court.
First jurisdiction regarding that, my lord, trial court at Calcutta. And I, my lord, whether your lordship has jurisdiction or not, that I am trying to bring it from 226(2), my lord.
No. Yes, Mr. Bhattakur, you also have a case.
Lordship, I am in item number 4. So far as your lordship, this issue is concerned, your lordship, my humble submission will be, if your lordship is exercising supervisory jurisdiction, your lordship, then probably your lordship may not have the authority to issue.
Because it will open, because I'm telling you everywhere that this can be very well challenged in Calcutta High Court. If it was an FIR being filed out there against the person out here where every activity is here, obviously this court can. But then also this court should not, because I have seen many problems out here. If you remember, there was one matter, you were there. Remember?
Lordship, that is.
You were the
Jharkhand-
response number
Jharkhand,
4.
Lordship.
You see, the problem is with this court faces. You don't get the person out there. They are least bothered. But it becomes very difficult. Here we have the state of West Bengal here. But the state of West Bengal has no business out here. These are complaint
Lordship,
cases.
that is-
But in that case, the state of Jharkhand was involved. They are not bothered. In spite of notice, nothing, they are bothered about that. So the only way we can extend our jurisdiction in FIR very well. But doing that also, we have to be very careful on these aspects. Now, in these cases, these are complaint cases. Tomorrow, why not a person, a defendant may be here in Guwahati, a suit having been filed there. Why not exercise a jurisdiction against 115? 115 will lie.
No, your lordship, kindly,
Or
one.
227? Why not? Against a non-filing of a written statement being given by the Calcutta court, why not exercise 227 here? Or 115 or do whatever may be. These are exercise of jurisdiction which has to be limited. These are judicial orders. I can quash a complaint. But if it is a case where there is no case made out, that is a different aspect of the matter. But to say that I should exercise my jurisdiction over the issuance of process, then it becomes a difficult.
Kindly see one aspect, your lordship. So far as my case is concerned, your lordship, I have no idea, your lordship. My case, your lordship, is sheer abuse of the process. Your lordship. What has happened, your lordship? They have filed a complaint case here, your lordship, that is pending, your lordship, and a execution case proceeding, your lordship, in some arbitration matter, your lordship, relating to the same loan, your lordship. is pending in Sibsagar, your lordship. In spite of that, your lordship, they have preferred in your lordship complaint case before the Calcutta court, your lordship, only to your lordship ensure that to harass me and to ensure that I make the payment, your lordship. Now, in that view of the matter, your lordship, in my humble submission would be, it is a sheer abuse of the process. And when such abuse is palpable before this honorable court, whether this honorable court, your lordship, will protect the citizen or not, that probably, and your lordship will, what has fallen
As
from
regards an FIR or a complaint as it is,
lordship,
without going into the order, it's a different thing.
lordship,
But whether a case has been made out or not in the complaint,
lordship.
if a case is being made out, then I can't touch it. If no case is made out, then it's a different thing, because where you are touching the complaint, not the issuance of process.
Lordship.
But the moment there is a issuance of process, it comes within the ambit of a Calcutta.
So far as my humble submission will be, your lordship, if your lordship go through this particular complaint case, your lordship will find the based on a loan agreement, your lordship, they have filed this, your lordship, for non-payment of non-repayment of your lordship loan, your lordship. And apparently, your lordship, no criminal case is made out, your lordship. It's a surely a civil dispute in nature, your lordship. From their statements in the complaint, that has become clear, your lordship. Now, your lordship will find, your lordship, so far as 227 is concerned, your lordship.
227, I have no problem.
Lordship, that's what has fallen from your lordship's mouth, your lordship. That's his jurisdiction, your lordship, which will not confer this honorable court to pass an order against the court, court below, your lordship, which is not within its jurisdiction. So far as 226(2) is concerned, even if your lordship, I am going through the parliamentary debate by which these provisions are brought in the constitution, your lordship will find what is the purpose for which this particular provision has been brought in the constitution. Your lordship, for a moment, your lordship, kindly go through this parliament.
Yes.
Lordship, when your lordship, honorable apex court, your lordship hold that the writ jurisdiction, under the writ jurisdiction, the high court cannot issue a writ of mandamus when the cause of action is not within the court, the state in question, your lordship. In that view of the matter, your lordship, this particular amendment was brought by the parliament, your lordship. Your lordship will kindly, the very first phrase, your lordship. Third page, your lordship will find. Second paragraph. The next provision is with regard to the jurisdiction of the High Court to entertain application under Article 226 of the Constitution. When the Constitution was framed, it was never intended that all application for the issue of writs, high prerogative writs against the Union of India could only lie with Punjab High Court.
You are reading which paragraph?
Lordship, page number third page of this particular copy, your lordship.
Got it.
Writs, high prerogative writs against the Union of India could only lie with Punjab and High Court. In fact, the decision of the Privy Council in the older case was quite the other way. They held that it did not matter whether the authority resided, it was really the cause of action which should govern the question of jurisdiction. In the famous Parlak Medi case of Board of Revenue was resident of Madras State. Nevertheless, the Privy Council refused to allow the writ petition filed or the original site of the Madras High Court, though it possessed the authority to issue writs against the Board of Revenue on the ground that the order complaint is related to matters outside the original site of Madras High Court jurisdiction. Therefore, what the Privy Council decided was quite
Mr. Bhattakur,
Lordship.
the question that this court can have a jurisdiction in respect to the complaint is not the question.
Lordship.
I'm not on the challenging on that. But the moment the process has been issued,
Lordship.
this court can't set aside the process. That is what I'm saying. I really appreciate.
Lordship.
No case is made out, I can very well access. this.
Lordship.
Because there A part of the cause of action happens.
Oh.
But when the process has been issued,
Lordship.
then the cause of action wholly happens before that, if you are agreed by that. If you have a case, like in one of the cases, if I'm, that day these matters came up, one of the cases, it's a case of the violation of 202. If it's the case of violation of the 202, can this court under 226 exercise that power, set aside that order? Because 202, if I set aside, what is to be done? The next course of action is to ask them that the process is bad, you make an inquiry, and thereupon you proceed. Isn't that? So if that be so, this court can't do that. It is for the Calcutta High Court to do it. But as regards 204 process, this court can't touch that. But this court can very well touch only to the effect that in no case is made out in the complaint. That I can take it from Bhajanlal itself. I'm not on that, but therefore, I don't require these judgments for that. But that law, I think I am clear on that. That it will still follow the principles of 20 of the CPC. When you are doing under 226(2), the principles of CPC in section 20 is very well involved, whereby if any part of the cause of action happens also, it can be very well exercised. There's no quarrel on that. But some part, whether that is a main cause of action for approaching this court is a question which can be looked into. But if it is not, but issuance of process is not a part of the cause of action, it is the whole of the cause of action which is there.
Lordship, therefore, your lordship, so far as my prayer is concerned, your lordship, my prayer is for also quashing the proceeding itself, your lordship.
Chalo, we question then. Yours,
Yes, because the complaint itself doesn't disclose any ingredients of 406 and 420. In the petition, yes, complaint is by way of
show me that.
affidavit, additional affidavit.
What is the complaint? Your writ petition is 7544. Where is the complaint? Huh?
180,
Page?
page 59.
No, page 59 here. 7544 is whose?
Third one. So 189.
Okay. Where is it? How much loan did you take?
Well, 12,73,000.
And how much did you pay?
Complaint paragraph 5. Very tight, you know. The accused repaid some of his legal liabilities. So, formatting CDOT's it is clear that from the inception, there was nothing,
Yes, Mr. Dev, where is the initial deception?
And your lordship will kindly note, your lordship. They themselves is not sure whether it will be initial from the initial deception or entrustment. Therefore, in their petition 406 and 420, they have brought.
Both can't go
but
together.
cannot Go together, your lordship.
Tell me.
Just go through the complaint below. In fact, this copy was not served upon me. Just
Huh?
the copy
This
of the.
matter has been going on for such
No,
a
no,
long
this copy
time.
that probably it was served upon the government. I
It was served upon you. The
I-
matter notice has been issued as far back as
No,
on
no,
such a time.
so for the IA is concerned, below Miss case is concerned. Sorry, below the affidavit is concerned.
Right?
I just go through it. Just,
I'm not on to the affidavit. This is the part of the petition, isn't that?
no. It was filed subsequently below.
Oh, you did not file the complaint.
The complaint is not was not filed with the.
What did you challenge here?
Challenge is below the proceeding in the complaint proceeding.
Where is your statement in your complaint? That in your petition that no case is made out?
In my petition, your lordship.
No, your will take it. Yes, where is your thing? Your case is on absolutely on another aspect. You can't bring it by way of an additional affidavit. You don't have a case. Go to Supreme Court. No. Why should I look into that? First of all, you did not enclose the complaint. You need your basic case is the process or issuance of process was wrong. That is your case. Heard Mr. Sahu dismissing it.
Where
That is Supreme Court.
the liberty to file. Otherwise, without complaint afford itself, it is the case that they have not made out any case against me. They have not made any case against me.
I'm not going to say anything. I was only asking him. I never said that he has not made a case.
Secondly, because if I may be allowed to withdraw and file FS, which, because there is defect in drafting of the case, and there is nothing else.
Mr. S. Sahu, the learned counsel appearing on behalf of the petitioner submits that he would not like to press the instant petition, taking into account that there are certain formal defects. He, however, submits that he may be permitted to refile by removing those formal defects. Accordingly, the petition stands dismissed on withdrawal. However, liberty is given to the petitioner to refile by removing those formal defects. Yes, 74544. Same. We've gone it on. Yes, now give me item number 4.
4. In para 11, your lordship, I have stated that there is no prima facie case.
Where is it, paragraph?
11, your lordship. that it is humbly submitted that a bare perusal of the complaint case number so and so prima facie does not disclose commission of any offence. This one complaint has been filed with a mere assumption of an offence to be committed.
This is also nothing doing.
And para 13 also, your lordship.
You are again on jurisdiction aspect. Jurisdiction, this court, what you are asking
Lordship,
for,
that
these things.
there are statements, your lordship, on that point also, your lordship, but your lordship, ultimately our basic case is this.
Your basic case is not that. You are even assuming. One line you are saying.
Lordship,
Where is your case? That no 406, 420 can't be there. Where is your case? Nothing there. What is this case for?
which one, your lordship?
This is
My-
a negotiable instruments
Page
case.
41.
They have negotiable instrument cases before here.
Page
Your lordship.
41.
Page 41 is the complaint, your
Or it's the same type.
lordship.
This is also not the same case.
Page 41 is the case, your complaint case they have lodged, your lordship.
So where is your case made out to that effect? Why should this court? Your case is basically on that. Your case should be on the other aspect. You may very well say that look at these other aspects we need not go into. Means that in view of the complaint not being cannot survive. Therefore, the proceedings needs to be stayed. That should have been your case. You are on the other hand again questioning on the question of territorial jurisdiction of
is the-
filing. That is not your case. That cannot be the case.
That is there, your lordship, but that's why your lordship. At the
Okay,
same-
let me dismiss you. You go to the division
Your
bench.
lordship, then your lordship, similar order may be passed, your lordship, I will also file.
This
a
type
press.
of cases means something has to be done like this. You can't keep on doing it like this. If you have a case to that effect, but you see what you are asking for. Mandamus should not be issued directing so and so to recall the warrant of arrest.
So that is,
Look at these orders. This is your main play. Only assuming for argument's sake. You're only, it is like a caveat that look here, there is no cases made out, one line. But all the entire thing is different. You see, the complaint should not be following Pepsi and all, or even there are very recent judgment that this is a purely a civil dispute. Where is the question of making a case? You should have come up with this type of case. This is not the case, because otherwise it will portray a very wrong picture out there. How can this court set aside this thing?
since your lordship, then your lordship, I may be allowed to withdraw,
And why you are making the police station a party?
lordship. Because your lordship, these were sought to be executed through the Simoluguri police station, this NPW, that's why.
No, but the moment that order is stayed, the proceedings is stayed, why do you need another aspect? You don't require it.
They come up with your lordship, this.
You are troubling only Miss
Lordship, that-
Shivachaji. Don't trouble her. Let her go. I gotta withdraw. Liberty.
Deeply obliged.
But Mr. Day, your client's
Understand. In fact,
conduct
there-
is not clear.
in fact, my lord,
Let him file it.
Lord.
Give a copy to him.
I-
We'll quash it on the first day.
Lord.
This is
Deeply.
absolutely not.
procedural defects, my lord, that is clear.
You should not have done that. This is absolute. We may also ask the insurance. You have that insurance thing, na? You are an insurance company.
No, here it is basically finance.
What are you?
It's a finance company. We finance for vehicles and other.
Find out there is one act where these people do something. We'll pass appropriate direction to these people. It's not done.
May it please your lordship. This is regarding an issue of re-election in cooperative society pursuant to the body being dissolved by exercise of section 39. If I may just place a judgment, lordship, because what I am submitting is, it is a covered matter. Division based matter is judgment is there. It's placed there, lordship. Lordship had the occasion to look into this matter the last week. What has happened here we were the board of directors of this particular society. So, page 18. Page 18. Last line. This was a case where they had come up with the challenge that the board been dissolved on section 39. They were seeking extension. And also they had another prayer that they should not be disqualified for re-election in the upcoming elections. So now page 18, if a lordship will see one sentence. Page 18, the last two lines
Oh,
of the judgment. He will also be taking up the judgment. The last two lines. Page 18, last two lines. The second aspect regarding that debar or the disqualification has been discussed here. So I'm just placing that. The first aspect of extension, that is out of contention. It is submitted that furthermore, there is a strong apprehension that because of the automatic dissolution of the board of directors under section 39 of the Act, although the appellant in WNMS Essentials is not opposed to holding fresh elections for electing the members directors of the board of societies, in view of the provision of section 40, subsection 4A of the Act of 2007, there is an apprehension that the appellants may not be permitted to participate in the elections which will be held in the near future for the cooperative society. Now, this was the question that was in front of this honorable court because there is a bar. Now, this bar has been thereafter interpreted, and that will also be find at page 28.
the election is over.
In our case, election is yet to come. Because, but the disqualification, they have already issued one letter that within 30th of September, the elections will be held. That I have already submitted for the last of the year.
So you saw that before that authority, this judgment. Why should
Sir,
this court include it?
my only prayer.
You don't have a case. Your case is to be dismissed on that day I wanted to dismiss it. Mr. A.R. Bhuya sought for time. Isn't that Mr. Taluk?
Yes. So if I may be just allowed to submit.
So all these things before them, why you are
Yes.
showing it to
Because
me?
my
Your
only-
basic case is that you may be disqualified. I say the question whether the elections will be held, you will submit. And thereafter, if anything happens, you can very well file an election proceedings out there or even file an application under 45 if it is not to approve the meeting, if it was held. All these avenues are available. Why should this court at all entertain this type of petition in
Because-
apprehension?
Because the cause of action arose when I was dissolved. The cause that
So
Lordship,
the law is there.
this
Do
law.
you need to come to this court every time that anything, a law has already been declared, tomorrow you will come, then kindly hold the meeting in terms with section 34 also. Have the quorum. Why?
Lordship,
Why do you need a quorum? No,
my-
tell me, tomorrow you may very well come. They may hold the meeting against not in terms of a quorum.
Yes.
So kindly follow 34. Get a read. Read the
No,
mandamus,
I'm not
these
on
are
that.
high prerogative
I'm not
reads.
that, Lordship. Provisions of the Act, I'm not here to enforce. What I'm saying is, this judgment was passed vis-a-vis the petitioners therein. My only prayer would be, while considering our case, the observations made in the WA,
Who will consider?
the register.
Why?
I have already.
Why will
filed
the register consider?
I have already filed. An
No, no. Why will the register consider? As of now, there is no election notification issued.
Yes.
Election notification will issue. You will submit your nomination. Your nomination, after being submitted, it may be accepted or rejected. At that time, very well you can show the judgment.
The bar.
And wait, this judgment can be very well shown then. These people may understand, may not understand. If they don't understand, then within 3 days you file an appeal under 26 or 29.
7.
Matter a day. Then why
I-
should this court preempt any proceedings that kindly follow this judgment? Then it is there. The judgment is
Because the
already there.
judgment is vis-a-vis or per se the petitioners therein.
Nothing doing.
I'm just praying that the observations may be taken into consideration because also
No.
the bar is already existing.
You do one thing. Go to division bench. Let me
No,
dismiss
no.
it with cost.
So,
For unnecessarily filing. You are asking for a high prerogative reach. Reach are
Not
not to
high
be issued just
my-
for idea.
Lordship,
Just for the sake of it.
Lordship, just appreciate my concern.
No, I
Section-
appreciate your concern. Your concern will only come into being when you submit. Tomorrow, something happens then. Should I pass a writ to that effect that kindly consider the petitioner's case when there will be a notification, they will submit and then kindly consider the judgment. The judgment is already there. Why do you need an endorsement? Are you saying that a division bench judgment has to be endorsed by a single judge?
Not saying
My
that.
goodness.
It will be
Heard
so
Mr.
only one prayer.
A. Sharma, the
I'm
learned
fine with
counsel.
representation if that
I
can
am
be considered.
dismissing your petition right now. Heard Mr. I should,
So
before
why?
notification has been issued, this court should pass an order
Notification
that
is only a
the
cascading
respondent
effect of the
authority should
disqualification.
accept the nomination. My
Lost
goodness.
the notification. The nomination will be only a cascading effect. The dismissal, the rejection of the nomination will only be a cascading effect of the disqualification that is already against me now. 39 been exercised, the disqualification is attracted. 44A. So I am already under a disqualification. So when I go to submit my nomination and it is rejected, that will be only a consequential effect. So I am challenging the very root of that difficulty of the disqualification under 44A. That was my case to my
As
understanding.
per you, because of this judgment, you should not be disqualified. Isn't that?
The observations made in the judgment would otherwise cover my case also.
Absolutely. Then
Yes.
why you are not showing that to that authority
I have submitted a representation before the authority.
before that? How is it possible? You submit at the time of your nomination that look here, this is, I am covered by it, don't reject it. And if they reject it, then you go before file an election petition that look here, they have rejected in spite of the categorical observation, the law being laid down by the division bench of this
Trying to
court.
prevent some things, Sir Lordship. Only that, Lordship. My
Nothing
representation
doing.
can be considered only that.
Heard Mr. E. Sharma, the learned counsel appearing on behalf of the petitioner. Mr. S.K. Talukdar, the learned counsel appears on behalf of the respondent numbers
All the
1 to 7. Full stop.
one my lord, Chief Secretary.
1, so and so, bucket 7. No, 1 also, Cooperation Department,
Chief Secretary.
Additional Chief Secretary.
One.
1 to 7. The petitioners herein have approached this court by filing the instant writ petition apprehending that in the upcoming elections to be held for the Board of Directors of the Ahom Bohumukhi Samavai Samiti Limited, hereinafter referred to as the Cooperative Society, the petitioners' applications, petitioners' nomination may be rejected, and as such, the petitioner have sought for direction upon the respondent authorities to accept the nomination papers of the petitioners, as well as also for a direction that this court should allow the petitioners to contest in the upcoming elections to constitute the new board of directors of the Cooperative Society. First, this court have inquired with Mr. A. Sharma, the learned counsel appearing on behalf of the petitioner, as to whether any notification for holding the elections have been issued as is required under the provisions of the Assam Cooperative Societies Act 2007. The learned counsel submits that as of now there is no notification, notification issued.
One communication is there, which says that elections will be held within 30th of September. That I have placed in the last opinion.
He, however, submits that there is a communication issued
6 September.
that by
the Zonal Joint Register Cooperative Society Jodhar.
by the
Zonal Joint
respondent number by the respondent number 6
Yes, sir.
that the elections of the Cooperative Society would be held in on or before 30th of September 2024. Also, the learned counsel submits that the petitioners herein are likely to be submits that there is a strong apprehension that the petitioners' nominations would be cancelled in terms with section 40(4)(a) of the Cooperative Act of 2007. On the ground that
The earlier board was rejected by exercise of section 39. It was dissolved by the exercise of section 39.
on the ground that not conducting or wrongly conducting the annual general meeting under section 39. That's the post.
Our body was suspended and therefore we could not hold our AGM.
This court, in that regard, the learned counsel have referred to a judgment of this court, of the division bench of this court, in the case of Jahirul Islam Law Court and versus Bokhtar Hussain, dated
It's reported lawsuit.
where
I have written 2022,
reported in 2022
4
4 GLR,
page
page 61, wherein the division bench of this court had
page 31, paragraph
observed
13.
that the embargo under section 40 bracket 4 bracket A was not attracted in the facts of those cases. He therefore submitted that the facts in the instant case are similarly situated.
Here also there was an apprehension. They came up on an apprehension. Paragraph page 18, shown that dual lawsuits. Page 18, last 2 lines was just that.
Mister, there was an order being passed on 14/9/2018 which was challenged. Why you are saying that they have come in apprehension?
No,
Don't make that such a, kindly come to page 9. Why you are making that submission?
no, so that
What? No. This is in that context it was said. That was an order of 14/9. I've also heard Mr. S.K. Taluk, the learned counsel, appearing on behalf of the respondents, who submits that the instant writ petition is a premature writ petition. He submits that the petitioner has expressed their apprehension, which are based on certain facts which needs to be looked into. And the same cannot be looked into at this stage without the notification being issued and the petitioner being debarred. He further submitted that if the petitioner duly wants to press the judgment of the division bench of this court in Jahirul Islam Law Court, Supra, then the same very aspect can be placed before the election tribunal, before the returning officer, or if further agreed before the election tribunal in terms with section 29 of the
27.
27 of the Assam Cooperative Society's Election Rules 2019. This court, having perused the materials on record, is of the opinion. This court have given have heard the learned counsels appearing on behalf of the parties and have given an anxious consideration to the respective submissions. Also, this court, upon perusal of the materials on record, is of the opinion that the instant writ petition is premature at this stage, inasmuch as till date there is no notice issued for holding the elections. Apart from that, the cause of action for the petitioners at best would only arise if their nomination is cancelled, further in terms with section 40 bracket 4 bracket A of the Act of 2007. In addition to that, if the nominations are cancelled, then the petitioners have an alternative and efficacious remedy in terms with Rule 27 of the Rules of 2019. Under such circumstances, this court is not inclined to exercise its rich jurisdiction in the present stage. Yes, Mr. M.K. Das, did you improve your thing by filing an additional affidavit in?
I filed, my lord.
Huh?
I filed. I
What
filed.
have you named it? Additional affidavit. Okay, you have brought in that document
My lord.
wherein the circle officer have asked these people
Yes, my lord.
as to why that building, the wall should not be demolished.
Wall, my
Sure.
lord.
We issue notice.
My lord.
Now it becomes complete.
Yes,
Otherwise, it was later on, you will have again a problem.
yes, ma'am.
Okay, issue notice making it returnable on 11th of November 2024. Pusto. Mr. N. Goswami appears on behalf of the respondent number 1.
3, 4, 5, 6.
Huh?
1, 3, 4, 5, 6.
3 also. How? Borpeta Road Municipality Board, how are you appearing?
Executive engineer.
You can't. Can you? No. 1, 4, 5.
Five.
5. Full stop. At the respondent, at the state council represents the state respondents, extra copies of the respondent petition be served upon him during the course of the day. As regards the respondent number 2, 3,
6.
6, and 7, the petitioner is directed to take steps by way of registered as well as usual within 3 days. You want an early disposal? In addition to that, the petitioner is also given the liberty to take effect service upon the said respondents, namely 2, 3, 6, and 7, by way of dusty routed through the registry of this court and file an affidavit of service on or before the next date. First, the case of the petitioner herein is that the respondent number 7 have constructed a boundary wall which is of the height of 9 feet.
My lord. 9 feet.
9 feet.
My lord.
Height of 9 feet. And which is and 9 feet. And the same is in violation to the what that?
41. Section 41
Huh?
of my lord, Assam notified urban areas other than Guwahati building.
Section Rule 41
Rule 40.
of the Assam notified urban area bracket other than Guwahati bracket close building rules 2014. Full stop. He further submitted that during the that the petitioner have duly approached the Borpeta Municipal Board, However, no actions have been taken. In addition to that, the Learned Council have also drawn the attention of this court to the additional affidavit filed on 11th of September 2024, wherein the communication issued by the circle officer, issued by the respondent number 5 to the respondent number 2. And Mr. Counsel, tell me one thing, how on earth are you going to serve these people without a proper address? Chairman, Borpeta Municipal Board, Borpeta. Finish. Executive Engineer, Borpeta Municipal Board, finished. Deputy Commissioner, Borpeta. Circle Officer, Bornogor.
Borpeta Road, my lord. They have a specific office there.
So that is enough. How are you going to put the pin code? Without a pin code, can there be a registered document sent? How? Tell me. And you have not made the executive officer a party also.
My lord,
Who is going to
the
appear?
Chairman,
Na-
my lord. Borpeta Road Municipal Board is. the
Now
authorized
the board
chairman.
is functioning.
My lord. My lord.
Also have referred to a document. Then why did he write to the executive officer on 16/8?
You ought to have written it to the highest authority chairman, my lord. Borpeta Road Municipality Board. my lord.
Have further referred to a communication issued by the respondent number 5 to the respondent number 2, wherein the violation made by the respondent number 7 have been duly reflected. The Learned Council therefore submits that no such action was taken in spite of that. And under such circumstances, the instant writ petition has been filed. Full stop. On or before the returnable date, the respondent shall bring on record their stand by filing an affidavit. Full stop. The petitioner, while effecting steps upon the respondents, including the respondents who are duly represented in the instant proceeding, shall also serve additional copies of the additional affidavit so filed on 11th of September 2000.
This was the same idea, Your Lordship, last time, my lord. My case is here, my lord. Your lordship, what I have gone through it. It is classification of the land. Our case, but they have already found. Part payment already made. Subsequently, he himself revoked that order.
Hmm.
That's why my payment has been now held up. Already part payment already made. So my case by the page 26 and your lordship can decide that.
Part payment made. And now he is stopping it.
Now he has revoked that order, my lord. This is the case.
Chalo, we dismiss your petition then. The order seems to be
No,
likely passed.
now you have to kindly say, my lord.
Because there being no classification by the respondent authorities, in terms of the Reclassification Act, he could not have made that land shown as commercial.
But their guidelines say, your lordship, and these are guidelines of the National Highway Authority, my lord. It's just I'm passing over.
What does he say?
Roman 9:10.
Huh? Roman 10.
Yes. Page 26, my lord.
Hmm.
On that basis, payment was made.
Show me any document by which your land has been shown anywhere to be commercial, except this document.
The lordship, kindly see my lord, page 22.
Huh.
Page 22. As per your lordship, kindly see.
Yes, right?
As per second aspect of the class of the land involved in that is Shaiduga, and at present, the class of the land is recorded as commercial in third aspect.
It is recorded as commercial.
Yes.
Class of
They are
the
gonna
land
settle
involved in the
themselves.
above dag is Sailpura, and at present, the class of the land is recorded as commercial in the third draft land records.
According to my lord, we.
Show me your this third draft here. Where is the land records?
Record I don't have my lordship fall back that can produce.
No. I have to be satisfied, not on these type of documents.
Then I have to produce mine.
Where is your land?
And what?
In this 3A notification,
Yes,
where is your land?
fine. Page 23.
Page 23.
Page 23.
Where is your dag number?
Doc number page 24, your lordship, 30, serial number 30 bottom,
Serial number?
24. Page 24,
Your agricultural lands.
no, my lord, then your lordship will find. Then we file objection.
You
Then
filed
the
objection.
Objection.
Then
Then page 26 comes.
what objection you filed?
If an objection that is now it is commercial.
But has the land been at all anywhere being recorded as commercial?
That is their same in third August, but it is found commercial. third August. Yes.
The third is no, that is a draft.
So on page 22, page 22.
Page 2, that is a draft only.
At present, the class of the land is recorded as commercial in August of land record.
You know?
And he himself might have personally visited the officer. He found thereafter page 26 now. Thereafter he go for his own mind.
Who is appearing for NSCI DCL? Well, we issue notice. Issue notice making it returnable on 2nd of December 2024. Mr. N. Goswami appears for the respond number 2, 3, 2, 4, and 5. Because extra copies of the petition be served upon him within 3 days. As regards the other respondents, that is respond number 1, 3, 1 and 3, the petitioner is directed to effect service by way of this by way of register as well as usual. Pustak. The case of the petitioner herein is that the petitioner herein have challenged the order dated 4/8/2020, challenged the order dated
No, mind, page 28.
13/3/2024, passed by the respondent number 3. This you can appear, na? 3. Okay, 2, 3. Oh yeah, 2, 3, 4, and 5. He appeared. And 1 is by, and you have not made the NHI DCL a party.
This is a party. DC.
Who is going to pay the money to you? Who is going to pay the money to you? Kala is not going to pay. Kala is a competent authority only.
National Highway.
Then why they are not made parties?
Respondent number 1, madam.
Respond number 1
Yes.
is not the National Highway Authority.
Yes, madam. Represent.
You have to make the national, what do you call this is? National Highway Infrastructure Development Corporation Limited, a party. Without that, anyway, this matter will go for a 6. Nothing is going to happen. Yeah. The case of the petitioner is that the petitioner is aggrieved by the order dated 13/3/2024, whereby the respondent number 3 have rejected the claim of the petitioner that to the effect that the land in question is a commercial land. This court have inquired with the learned counsel appearing on behalf of the petitioner as to whether the land of the petitioner have been classified to be a commercial land in terms with what is that act known as Assam?
Some. Yes.
In my judgment, it is
Yes.
given out.
Assam Agricultural Land Regulation of Reclassification and Transfer of Donation
2015.
15.
15. So the learned counsel, however, was not aware as to whether any proceedings have been initiated under that provision to reclassify the land of the petitioner from agricultural to commercial. He, however, referred to the certificate being given on 21/1/2023 by the
System.
Assistant Settlement Officer. A question, however, arises as to whether such type of certificate can be in consonance with the provisions of the Act of 2015. Be that as it may, the respondents, more particularly the respondent number 2 to 5, shall bring on record their stand as to whether such a certificate dated
21/1/2023.
whether such a certificate dated 20, which is enclosed as Annexure 3, is in consonance with the provisions of the Act of 2013. Further to that, in their affidavit, they shall also intimate this court, apprise this court as to whether the land of the petitioner are agricultural lands or have been or are commercial lands. Full stop. This court keeps the maintainability of the writ petition open in spite of issuance of the notice on the grounds of availability of alternative remedy as well as on the ground of not impeding the requiring authority in the instant proceedings.
Without the intent, but we may.
You do it, which
Let's do it.
keeping it open only.
Okay.
What is this?
May I please, your Lordship? Lordship, in this case, Lordship, we have challenged the Lordship impugned order at page 78. Lordship, our main ground of challenge is that Lordship, the so-called notice which was issued to us, Lordship, was issued by the respondent number 3. Respondent number 3 had issued me the so-called notice. Lordship may see the so-called notice at page 73. It starts at page 73. So-called notice is 73. Before that, Lordship, the DRC one is there. 73, the notice starts at page 76, Lordship. The name of the officer is there. The Deputy Commissioner of State Tax, Lordship.
Where?
Page 76, down below. Lordship, the Deputy Commissioner of State Tax. Lordship, may kindly also see the first paragraph of this page. Now, in view of the above, so-and-so holding so-and-so Dubri is called upon to show cause to Deputy Commissioner. Lordship,
Where?
Lordship, the 76, page number 76 only. The first paragraph, now in view of the above. So-and-so is called upon to show cause to the Deputy Commissioner of State Tax. So he is asking to show cause before him only. Sometimes, Lordship, what happens as in DGGI, they issue the show cause notice, but they ask me to appear before the assessing officer himself. Now, this Deputy Commissioner has asked me to appear before him only for showing cause. But however, the impugned order which has been passed by a different officer. No opportunity of hearing has been given to me by him. Lordship, page 86. The impugned order is, Lordship, starts at page 83 and it's at page 86. This is the Assistant Commissioner. This is the respondent number 4. Has passed the impugned order. Lordship, this officer have never issued me a notice, and without hearing me, the officer could not have been passed the Lordship impugned order.
Did you reply to this so far?
No, Lordship, because I have only asked for a time, Lordship, adjournment petition, because it was 23-24, Lordship. They had got lot of time to pass the order of assessment. There is a, Lordship, at
Go
page
file
77.
appeal.
Page 77.
Go file appeal.
Lordship, so far as this is there, this cannot be considered by the appellate authority. Lordship, there is another aspect of the matter. Lordship, this is a assessment order for 23-24. But Lordship, this in this assessment order, only 23-24 the amount can be taken. They have passed the order taking into account the amount of 23-24 also. Lordship, may kindly see the Lordship Soko's notice at page 73. The first point, which is there. Point number 1, page 71, Lordship, point 1. On 10/4/23, the taxpayer claimed a refund of rupees so-and-so for the tax period March 22-23. Second point is, Lordship, on 39, the taxpayer claimed refund of rupees so-and-so for the tax period 23-24. There are 2 assessment periods, Lordship. But Lordship, these aspects cannot be gone into by the appellate authority. I could have filed, Lordship, the appellate authority can only see the merit of the case, whether the amount has been rightly, Lordship, or wrongly. But Lordship, once an order, Lordship, may kindly see that in Whirlpool also has been
No case.
Lordship, then if there is a violation of principle of natural justice, now
There's no
somebody,
principle of that. You received the notice, you even did not do anything.
Lordship, I
You-
did, Lordship, page 77, Lordship, may kindly see.
No, we are in receipt of a so-called notice in this connection. We'd like to inform you, we have received the notice very lately, just few days back, as in so and so. This order, why did it stop you from here?
Lordship,
And
there
I
are
therefore request you to refix
Yes.
the matter after 4 weeks to enable us to give this notice and through the notice and check our documents and papers. Then why didn't you submit your
Lordship,
reply?
thereafter, Lordship, they did not issue me.
Why
any
will
notice.
they keep on giving you?
Lordship,
You
they
should
have-
have.
Lordship, this is a
And
procedure.
then when the notice has been issued, you are asking you to submit the reply when?
Lordship,
How many days you are given? 30 days.
30 days, Lordship.
So 30 days, there is no date fix also. Then 9/4, you on 30th day, you have taken this adjournment. Go there.
No, Lordship, may kindly, Lordship, may bear with me.
Okay.
Lordship, there is a, Lordship, when the order of assessment is passed, Lordship, before that, Lordship, at least a notice of hearing, when the Lordship notice is passed, Lordship, opportunity of hearing has to be given as well as a
You
notice
did
of
not.
reply.
What is there to hear?
Lordship, there is a
You did not
procedure.
reply.
Lordship,
You
the
did not reply out there.
Lordship, for giving a reply, Lordship, normally, Lordship, the procedure is that it is not that any day I can go and give a reply. They fix a date, Lordship. This is,
Where is the date fixed? Tell me.
Lordship, there is,
Where, no,
they did
where's
not
the
give
date
me
fixed? No, you are asked to submit within 30 days. Matter is very clear, page
Lordship,
76.
they did not even give me personal hearing. Lordship,
These are
apart from the,
person, not there.
apart from
What is there to personally hear? You have not submitted a reply.
Lordship, the reply as well as personal hearing are two different things, Lordship.
On one
Lordship-
hand, you want to delay hearing these type of matters, and the other hand, you have nothing.
Lordship, in this case, Lordship,
Hello.
this is assessment
Okay,
is 23.
dismiss.
Lordship may kindly, Lordship, I will
Heard,
take
miss.
some judgment.
And
Lordship may,
judgment division bench.
Lordship,
Heard, Miss
In this-
N. Haveli, the learned counsel appearing on
Lordship,
behalf. No, nothing doing.
Lordship, the same day they have blocked my ITC and the same day they have passed the order of
What?
assessment. The same day they have blocked my ITC and the same day they have given effect to it in the order.
Very well,
Lordship,
very good.
they cannot do it, Lordship.
They cannot do it. This is not the question
This is
out
not
here.
the-
Now, first, are you challenging the order of 74 and at page 78? Who and file appeal?
Lordship,
So cause notice was
Lordship-
given since no payment has been made within 30 days of the issuance. Therefore, on the basis of the documents so and so, with the department, furnish if any demand is created for the reasons or other details attached in the annex C. Where is the annex C? DRC order 54. Well, detailed order has been given.
pass with some other officer. He cannot pass an order without hearing me. He has not issued a single notice to me. This officer has not issued a single notice to me. Lordship, the first notice, the so cause notice was given to me by another officer. DRC 7 order has been given to me by another officer.
Is it somewhere written anywhere?
Lordship,
That officer?
Lordship, the order.
No, is that anywhere given in the CGST or the AGST or that the person who issues the notice has only to pass the order?
Lordship, Lordship, it's
Or
a.
is it your case that you went to the deputy
we are
commissioner's
actually-
place to do the hearing? He said that I am not doing the hearing, it is done by the assistant commissioner.
Lordship, if you would have said this, then it would have been better that yes, you go to the assessing officer. But instead of that, the assessing officer without hearing, he has not even issued a single notice to me. That is violation of principle of natural justice. Lordship,
Also, why? Because of that. That is not your case that you went there to deliver it to to do the hearing before the DCIT, and the DCIT has said that no, I am not doing it. Go to the ACIT or didn't inform. That is not your case.
In fact, that is permitted. If he would have said that you go and appear before the assessing officer, Lordship, that would be it would not be violation of natural justice. The violation of natural justice has occurred because A officer has given me the notice, but B officer has passed the person who hears me. That officer can only pass the order of assessment.
Where?
This is just, Lordship, this is the.
Hearing you did not. Hearing was not given to you because you did not submit your reply.
Lordship, the reply, this person has not given me a notice, Lordship. How will I reply before
Are?
him?
Forget about that. Did you go and submit your reply before the DCIT?
Lordship, they have not given me a date.
Then,
Lordship,
where is the date mentioned? Where is the date mentioned of filing a reply? You have taken it casually? Nothing doing.
Lordship, this is a procedure, Lordship, before the.
Procedure is there. Procedure is for these tribunals to look into. I should not look into all this.
Lordship, because this is a Lordship demand order, Lordship. I have got the Lordship, the amount has been refunded to me. Lordship, they have issued the recovery order. Lordship, this is a recovery order because Lordship, if they have given a refund to me after going through all the papers and the documents, and after
Then why didn't you reply?
Lordship,
Within the time, why didn't you reply?
Lordship, this order was passed, Lordship, without hearing me because.
Why? Why didn't you reply? You got time till lot of time. The order on 8/5 you go there, give me 4 weeks time to reply. Then also I would have understood you have submitted a reply to the DCIT, whether order has been given or not. Then also you have submitted. You can't take these things so lightly. Your client has to suffer, go there, pay 10%.
But Lordship, I saw the judgment that if the same officer before him, Lordship, this officer who has issued me the so-called notice, Lordship,
Those
that
judgments-
officer could have, if he would have.
Those
given-
judgments have to be shown before the division bench, showing it that look here, this single judge didn't hear all these things.
No, your Lordship, Lordship, may kindly, Lordship, allow me to play.
71
Lordship.
Column number 7, regarding personal hearing, my lord, the option is no. Petitioner has opted as no.
Where?
Down below, my lord, column 7, option for hearing, no.
Page?
Page 71. In the reply,
Reply.
page 71, annex 5.
No. Option for personal hearing, no.
Lordship,
Can't help it. Go there, go there.
Lordship,
Take all these, please.
Lordship, may kindly also see that Lordship, the order of assessment has been passed for 23-24. But Lordship, this is,
I am not going to look into all those things. Merit is not my business out there.
Lordship, I'm not,
I am not going to look into merits. Merits is not the cup of.
place one
Mary-
judgment.
These judgments are there. Go, division bench.
Lordship, I don't want to go to division, Lordship, from your
No,
Lordship. I am
nothing
very
doing.
confused, Lordship,
I am
Lordship.
not. Okay,
Lordship,
left.
Kindly, Lordship, give me one.
No,
more minute,
nothing
Lordship. I
doing.
will place some
And how
orders,
the
Lordship.
learned counsel appearing on behalf.
Lordship,
of the
last,
commissioner.
last submission, I would, may kindly allow me to make.
Hmm.
Lordship, may kindly see at page 111, they have issued me a notice under section 61.
Hmm.
Which is, Lordship, before the so-called notice, they should issue me a notice
Page?
under page 69, Lordship, annexure 3. 69.
Hmm.
Lordship, this is the notice they issued to me under section 61, which is for assessment year 22-23, Lordship.
59, 61.
69, Lordship. This is the notice, Lordship, under section 61. This is the notice before the so-called they have to issue, Lordship.
Which one? Page
Page 69, annexure 3, Lordship.
59.
69,
I
69,
think 69.
69, Lordship, page annexure 3.
Ah.
This is notice under section 61 for the assessment, Lordship, may kindly see down below. The assessment year is 22-23 for which they send me. Lordship, this notice, in this notice, they have issued me a figure that my ITC is available, but the ITC is available for a small amount. This notice, Lordship, thereafter they have dropped. So, Lordship, this amount they could not have taken once the notice is dropped. Lordship, this amount cannot be taken in 23-24 just because they have dropped for 22-23. They cannot take the same figure in 23-24. Once Lordship, inquiry against me has been dropped, Form 61, Lordship, they have dropped, they have not taken any Lordship action under this 22-23. All of a sudden, Lordship, this same figure they have taken in 23-24, and Lordship, they have passed the order of assessment against me. The same figure, Lordship, which they have dropped in under Form 61. The same figure they have taken, Lordship, and page 71, they have taken the same figure, 98,70,9074, which they had dropped under section 61. Lordship, may kindly see the figure 98.
I am not looking into all this.
Lordship,
This is not my business.
Lordship, there is a direct judgment of Madras High Court into that.
Go
effect.
to Madras High
Once-
Court then.
Once, Lordship, the notice.
Go to Madras High Court.
Lordship, once the notice has been
I
dropped.
am not bound by Madras High Court.
Lordship, Lordship, only for Lordship reference, Lordship, if Lordship may allow me to place that order
No,
before your
nothing doing.
judgment.
Nothing doing. Go there, go there.
Lordship, Lordship, the order cannot be passed by a different officer, Lordship.
Where?
Lordship,
Where is
once-
it? Show
Lordship,
me.
that's a violation, Lordship. I have got the justice.
I would have understood that if you have made out the case, then look here, I'm going to go there. I went out there, he does not inform me that the hearing is not there. And thereafter, I find that surprisingly, the Assistant Commissioner of Taxes passes on. Is that your case?
That is the case, Lordship. That-
Let's see your pleadings then.
No, Lordship, at page 77, I have replied.
Where
to
is your
the court notice.
pleadings to that effect, if that is the case? No. Yes, Mr. Gogoi.
Lordship, may kindly see paragraph, paragraph,
Very good.
paragraph 9. Lordship, in
Very
appeal,
good
appeal,
grounds for appeal.
Lordship,
Show those
appeal-
judgments.
no, Lordship, in appeal, they will not,
Those authorities will be bound by the Kerala Madras High Court judgments.
Lordship,
And
Lordship, the authorities in the appellate Lordship forum does not go through the Lordship, they will not be, they are only permitted to go to the merits of the case. They will not be able to see whether the person who has passed the order of assessment has either heard me or not. Lordship, my right has gone
are
away.
you saying that that ground cannot be urged?
Lordship,
Are you saying that that ground cannot be urged? What,
before the authority, because Lordship,
Why?
violation of principle of natural justice.
what principle of natural justice? There is no principle of natural justice out there.
Lordship, there is a principle of at least granting me 3 adjournments. At least 3 adjournments could have been given. That is
No.
a law laid down in the Lordship. Lordship, may
Where
kindly see.
CPC,
Lordship, in the GST Act.
show me
section,
that
in the section.
the 3 times adjournment is to be given.
Yes, your Lordship.
By the time 3 months will be over, GST comes out.
Lordship, may kindly see section 73 of the Lordship GST Act, Lordship.
Yes. Yes, where? Section,
73, Lordship.
tell me. Where 3 adjournments?
Lordship, there's a Lordship, a condition of 3 adjournments at least has to
Where?
be given. Lordship,
The entire scheme is to complete it within 3 months.
no, Lordship, the 3 months, 3 months is given, Lordship, for the notice. Notice should be at least issued.
Say anything contained in subsection Iman shall subsection ER shall pass where an order of amount of assessed Iman tax has not been paid within a period of 30 days. Where
Lordship, section 75, subsection 5.
20? 25.
No, this is not the section.
Then no case.
Lordship, there is, Lordship, may kindly permit, allow me just 1 second,
This is
Lordship.
for registration.
No, not 75, Lordship.
Yeah. Now you have exceeded your time limit for the matter. Any matter thereafter, if I dismiss the petition, per minute it is 10,000 rupees cost. Yes. Tell me.
Lordship, I will show in section 73, Lordship, the
Page
section
section?
73, section 73.
73. Which section? Where? That is only there in the CPC.
No, Lordship, there is a,
There
Lordship,
cannot be 3 adjournments.
Three
My
adjournments.
goodness.
Lordship, the 3.
You have been
adjournments
given
is there.
30 days time to file your. You didn't file your reply. You asked no, I don't want personal hearing. What is the officer going to do?
Lordship, section 70, Lordship, section 75, subsection 5. Lordship, it's there in 73 also, I'm not able to find 75, section 5.
Yeah. Shall, if sufficient cause is shown by the person chargeable with the grant time to him and adjourn the hearing for recording, provided no such adjournment shall be granted for more than 3 times. Then
Yes, sir.
what does it
The
mean?
Three
First,
three
there has to be
adjournments.
satisfaction. The satisfaction, if it is not there, here they put that there cannot be more than 3 adjournments. That is what it says. It doesn't say that we will be entitled to 3 adjournments.
But Lordship,
Adjournment is
but-
a matter of rights. And
Lordship,
this is for only for hearing. Kindly see
Lordship, for
this.
hearing, for
You,
hearing,
you say that I don't want hearing. Kindly see.
Lordship.
An opportunity of hearing shall be granted where a request is received in writing from the person chargeable with tax here. The purpose shall, if sufficient cause is shown by the so and so, adjourn the hearing for the reasons to be recorded, not for filing.
Lordship, this Lordship, no, which is given over there, this is for that date. This is only for that date. For
No,
every-
only for hearing,
Only for that date hearing.
not for filing.
Yes, sir.
Okay.
Lordship, the without hearing, Lordship, they have, if supposing I have not filed a reply to the SOCA's notice, they could have at least granted me a Lordship time for hearing. They have not given.
No,
me
you
any
said
Lordship
that I don't require hearing.
Lordship, for that date, only
No,
for that
no.
date.
Why will they say? Here is, no, that cannot be that date. Here they
Lordship.
ask you, no, here they are particularly, they asking it in this manner. See the form.
Lordship, this is the
Option
format.
for personal hearing, no.
Lordship, may kindly see this DRC 6 which is there. This is a Lordship format for Lordship filing. Whenever I give a reply to the SOCA's notice, this is a
You could
format.
have ticked
Even-
here also.
even-
You would have ticked here also. Yes. Why didn't you ask?
Lordship, for that hearing only I have now opted, not for other hearings, Lordship. If, because they have not.
This is your reply. DRC C 06 is for your reply. What is your reply? You see, I had no time to give you a reply and all to all these things. I need more time. Then why did you submit it?
Lordship, at least 3 adjournments could have been granted by the Lordship as mandated in the law. And Lordship.
That
such a
is
law-
not the mandate in the law. If you are not saying that I don't want an adjournment, then why should you not? Why didn't you go immediately thereafter? What happened on 8/5? After this?
Lordship, after this, I have not received any notice, Lordship. This is the
No,
procedure.
they are not going to issue notice. What did you inquire?
Lordship, immediately this order has been passed because
GST
Lordship, this
matters
officer-
cannot be in this manner.
Lordship,
What
this
has to be
officer
very
which is-
strict? Payment has to come.
Lordship, this respondent number 3, Lordship, was transferred to some other place, so how will I, Lordship?
Oh,
This Mr. John Sona, Lordship, the officer, Deputy Commissioner of State Tax.
ah.
So Lordship, we had visited.
Are
him
we
personally.
concerned with the officer or concerned with the office?
Lordship, there are, Lordship, I should not place, but there are matters pending against him. There are inquiries pending against him. Lordship, I am very sorry, Lordship.
I have nothing to do with that. Inquiries are pending against him. Good.
Against this particular officer, Lordship.
Then
In respect
that
to many
cannot be a
cases,
ground. That cannot be a ground.
Lordship,
No case.
I can place Lordship. One more date, Lordship, I'll become better prepared next day, Lordship. On Wednesday, your Lordship may kindly, Lordship, only one day of hearing may.
Only one thing. Can an officer, what is the rank of these two? The Deputy Commissioner of State Tax and the Assistant Commissioner of State Tax?
Lordship, Deputy Commissioner of State Tax, Lordship, it deals with the Lordship, a zone. And Assistant Commissioner of Taxes is my assessing officer.
And who is to exercise the power under 74?
Lordship, the assessing officer. Lordship, both the officers have the power. Even Deputy Commissioner have been given a power under section 74 to pass an order. He can also pass an order, even my assessing officer. My assessing officer is Lordship respondent number 4 and respondent number 3 had issued me a so cause notice, but both the officer have power to pass an order under section
So if
74.
both can pass an order, what is there? Unless you ask for personal hearing, I went there, that would have been different. How do I help you?
Lordship, I will be better prepared, Lordship, only Wednesday. I will, Lordship, place one or two
You have
orders.
spoiled almost 15 minutes of this sports time.
Lordship, I cannot
How
say,
much should be the cost, Mr. B. Gogoi?
Lordship, the
How
demand
much
is
per
2 crores,
minute?
Lordship.
These are huge amount. GST. Pension matters is different. GST is different. Per minute, it should be around 1 lakh,
Lordship, the
15 lakhs cost.
demand is, Lordship, more than 3 crores demand
So
is there, Lordship.
15 lakhs is peanuts for you. We'll again hear you 15 lakhs deposit the cost. Right, dismiss.
Lordship, may kindly, Lordship, for interest of justice, Lordship.
No, what is the interest of justice? Interest of justice, this court has to have there has to be the inspiration of confidence, which is not here. You have not taken your steps for that. Why did you put it? I don't want hearing. Why didn't you thereafter? Did you approach them? That we asked for 4 weeks. What did you do?
Verbally, we have.
What verbally?
Mr.
Did you put it on
The Deputy
letter?
Commissioner. State
Did you
Tax,
put a letter to the Deputy Commissioner?
I will have to inquire from the.
Then, so 15
I'll have
lakhs,
to inquire from the.
subject to 15 lakhs cost. 15 minutes, 16
Lordship,
minutes.
Lordship, there is a judgment of division bench also, but Lordship, I'll not like to place. it
Yes,
there.
yes, please,
That's on
please,
merits.
let us see what is there. Let us see what is the division bench say. Show
Lordship,
me.
that's on merits, Lordship. I have not,
Show me, show me.
challenged this case on merits.
Show.
I am only on the technical ground. Only on the technical ground that. Deputy
Why
Commissioner-
this can't be looked into
Lordship, this is
by
only on
the, yeah,
merits.
that an officer, because obviously you did not submit your reply there. Why couldn't the assessing officer do
Lordship,
it?
this is
You
on
do-
merits, not on the technical ground. Lordship,
Then-
in this case, I have only challenged on the technical ground. Lordship.
What is this?
Lordship, in the division bench, Lordship, this type of order wherein the Lordship, they have passed an order only because my dealers from whom I have purchased the material, their registration has been cancelled. So Lordship, in that event, the Lordship division bench have said that the orders are
This is
set
on
aside.
16-2.
16-2, Lordship. My case,
16-2. Your case is 16-2.
Lordship,
Why you are bringing this judgment? How does it going to help?
Lordship, the merits of, on the merits, Lordship, on the basis of 16-2, they have rejected my ITC. That is why, Lordship, I was placing the denial of ITC.
Understood.
They have rejected
Then
my
you have a division bench judgment, go there. In the morning, I sent Mr. A. Sharma for that. He
Lordship,
was showing me a division bench, they need to show that.
but Lordship, I am not challenging this case on merits. My only ground of challenge is, Lordship, the technical ground. Lordship, I have a good case, Lordship, if your Lordship. may
But
find it-
you don't, you have a good ground. There's no quarrel with that. But the ground is not made out by you. You should have, why did you put it that I went to go there? Means you should have had it that, okay, the deputy, I was never informed that the assistant commissioner would make the moment you are not asking for personal hearing, matter goes.
Lordship, Lordship, only this at least, Lordship, this from the Lordship client, I may be allowed to take at least this instruction, what they have done. So this 77 pages has been given. Maybe thereafter also there must have been some communication with the department.
Filed the writ petition without knowing that.
Lordship, because Lordship, in my opinion, Lordship,
Yeah,
that was sufficient that.
yeah, ITC is blocked. Fantastic.
On the same day, Lordship.
We will have it again on month of December. Winters are required to be heard. Why should we hear so early?
Lordship.
Winters. January.
Well.
Just before the Uruka.
Lordship,
Let the ITC be blocked for all this time. Then you will realize what.
Lordship,
So when is the list review? This is the matter again.
much obliged, Lordship. Much obliged.
Yes.
In the year, my lord, 1983, my lord, a plot of land 1 bigger, my lord, allotted in the name of my father. My lord. That is, my lord, allotment order kindly see page 21.
Where?
My lord, in the year 1983, my lord,
63.
83, my lord.
Where?
My lord, page 21. Thereafter, my lord, on that land, my lord, my father constructed house, my lord, and
Then after that,
after that, my lord, after the death of my father, my lord, my name also, my lord, recorded in the Sita of Sarvet place, my lord, that is page 26, my lord. My name is my lord Santosh Ali, my lord. Thereafter, my lord, I have applied online application, my lord, for getting settlement, my lord, in my name, my lord. That is, my lord, page 33, my lord, annexure 10.
then
Thereafter, my lord, suddenly, my lord, in the month of July, my lord, the respondent authority, my lord, demolished my entire, my lord, household property.
who?
My lord, the circle officer and the forester, my lord.
Why?
My lord, reason best known to them, my lord. Thereafter, my lord, I have filed a representation before the deputy commissioner, my district commissioner, but till that nothing has been done, my lord. I am a landless person, my lord.
Yes, Mr. Barbujari. What are these type of things we are doing?
Paragraph 8 of the writ petition, they say, my lord, that paragraph 8 of the writ petition at page 9. They say, my lord, that on 17/7/23, my lord, respondent number 4 and 6.
Yes.
Respondent R4 is the circle officer and R6 is the range officer.
No, I don't understand. When there is already an allotment being made in the year 1983,
Yes,
why he is asking for settlement?
yes, he is not asking for, and in fact, in the allotment letter also, if lordship may be pleased to come to page 23. I am trying to draw lordship attention to the vernacular. Original allotment letter, page 23. There, lordship will see in the second paragraph, topsil. Topsil, lordship will find, Kali, it is, my lord, 1 bigha. Then down below at serial number 7 and 8. This will assume significance. Serial number 7 says, Apuni e mati abonton hua aru tar babe আৰ্থিক সাহায্য পোৱাৰ অযোগ্য বুলি প্ৰমাণিত হলে এই আবণ্টন পোৱা মাটিৰ দখল এৰি দিব লাগিব আৰু আৰ্থিক সাহায্য হিচাপে পোৱা সমুদায় ধন ঘূৰাই দিব লাগিব। Then serial number 8. এই প্ৰমাণপত্ৰ ভূমি আৰু ৰাজহ আসাম লেণ্ড এণ্ড ৰেভিনিউ ৰেগুলেশ্যন 1886 উল্লেখিত একচনা ম্যাদী বা আন কোনো প্ৰকাৰৰ পত্তন বুলি গণ্য কৰা নহব। So it is only conditional allotment. Perhaps my lord, maybe at that time it is a question of fact, of course that will be clear on filing of affidavit. Perhaps there may be my lord erosion affected persons, that kind of thing. But it is not specifically spelled out under what circumstances this allotment letter was granted. They only say, my lord, that their predecessor in interest was a landless person, and then, my lord, the DC Goalpara has granted him this allotment certificate. And after this allotment certificate was granted, the Chitha was corrected. The Chitha lordship will find at page 26. Page 26. Chitha kindly lordship, see, my lord. This dark number, originally it was, my lord, 157. Now it has been changed to 202. And my lord, in the Chitha lordship will find, my lord, Pottar number aru Prokar. It is stated, my lord, as column number 4, Sorkari. So it still retains the character of a government land. Nonetheless, my lord, their predecessor in interest were allotted, they were occupying. So under what circumstances they were forcefully evicted, that can only be known, my lord, after filing of affidavit.
No, I don't understand. Once the land is allotted, these type of land allotments are being made in this manner.
Nowadays, it is not made, my lord. It is pertaining to the year
Let us
1983.
read the letter in Yasmin's hand.
Yes, madam. Assam Sarkar,
Down below.
আবণ্টন প্ৰমাণপত্ৰ উপায়ুক্ত কাৰ্যালয় গোৱালপাৰা। শ্ৰীমুখী জ্যোতি গাঁও চয়ঞ্চল নিম্ন তফচিল বৰ্ণিত মাটি আপোনাক ঘৰ সাজি ভোগ দখল কৰি থাকিবলৈ তলত উল্লেখিত চৰ্ত সাপেক্ষে আবণ্টন দিয়া হৈছে। So this is conditional allotment. লগতে এই মাটি কাম উপযোগী কৰিব পৰাকৈ 750 টকা আৰ্থিক সাহায্য হিচাপে অনুদান দিয়া হৈছে। Then serial number 2, my lord. Down below lordship will find আবণ্টন দিয়া মাটি আৰু আৰ্থিক সাহায্য দিয়াৰ চৰ্তসমূহ। Number 1 says তফচিল বৰ্ণিত মাটি ঘৰ সাজিবৰ কাৰণে আবণ্টন দিয়া হৈছে। উক্ত মাটিত নিজে ঘৰ সাজি ভোগ দখল কৰি থাকিব লাগিব। আবণ্টন হোৱা মাটি কোনো প্ৰকাৰে আনলৈ হস্তান্তৰ কৰিব নোৱাৰিব বা আন প্ৰকাৰে কোনো লোকৰ দখল দিব নোৱাৰিব।
দখল কৰিব দিব নোৱাৰি।
দখল কৰিব দিব নোৱাৰিব।
So you have allowed him to reside, construct houses,
Basically, it may be a case of permissive occupation.
whatever may be, but
Fine.
you have allowed him to construct houses. He makes houses. Then can you demolish it like this?
Therefore, my lord, only fact on filing of affidavit, because now since he has
Even, my
stated
lord,
that
without
he
issuing
has
any
already
notice.
been evicted. And he, in the prior portion, he says that, my lord, he wants compensation for the loss he has
And
suffered.
notice was issued,
No, my lord, no notice.
nothing.
No.
And there are no photographs in the writ petition also. There are no photographs in the writ petition also that his property has been damaged. It is only a statement made in the pleadings.
And why is the forest made a party? It's a
My lord,
forest land.
the respondent number 6, my lord, he physically, my lord, approached, my lord, while demolishing my house.
Who is paying for the forest? You served the copies upon the forest.
Yes, my lord.
Their names have perhaps not reflected in the court decision. And in the meantime, the petitioner have also filed a regular complaint case before the CJM Goalpara. Lordship will find at page 34. Against my lord,
This criminal, my lord.
against my
Yeah.
lord, R6 and others. R6 and others.
Yeah, but that has already been made a 156(3).
156, therefore, since question of facts are involved, so therefore naturally the police has been directed to cause an investigation.
And that
Now-
I will do it.
Yes, now here whether he will demolish,
Notice making it returnable on 23rd of October 2024. Mr. Arbokuzari appears for the respond number 1 and 2. Mr. N. Gusami appears for respond number 3 and 4. Forest, anybody? No. None appears on behalf of the Forest Department on call. Gusto. As the respondent numbers 1 to 4 are duly represented, extra copies of the petition be served upon them during the course of the day. As regards the respondent number 5 and 6, the petitioner is directed to effect service, take steps by way of registered as well as usual. In addition to that, the petitioner is given the liberty to take steps by way of dusty upon the respondent number 5 and 6 and file an affidavit of service on or before the next date. The case of the petitioner herein is that the petitioner father was allotted a plot of land at measuring 1 bigha covered by dark number 157 core
Court and the new, my lord, 202.
in the year under village Hasdoba within Lokhipur Revenue Circle in the district of
Walparam.
Walpara, Assam. Thereupon, on the basis of the said allotment, the petitioner's father as well as the petitioner have constructed a dwelling house. The revenues have, the land revenue was also accordingly paid in terms with the allotment. Taking into account that there was no settlement, formal settlement order passed. After the allotment, the petitioner submitted an application for settlement, which have not yet been dealt with by the respondent authorities. However, to the utter surprise of the petitioner, the respondent number 4 along with 4, 5 and 6 have forcefully entered into the land dwelling house of the petitioner and demolished the same. Under such circumstances, the petitioner had submitted a representation before the respondent number 3, but no steps have been taken in that regard. The petitioner, therefore, being aggrieved, has approached this court by filing the instant petition. The respondents, more particularly, the respondent number 3, 4, and 5, shall apprise this court on the next returnable date by way of an affidavit as to under what circumstances the petitioner was dispossessed from the land which was allotted to his father, and whether there was any notice issued prior to that too.
only one thing, my lord, he has not applied for settlement. He has applied for allotment. That is his specific prayer also, re-allot the land. Subsequently, it is not for settlement.
He asked for settlement, but the question is, you allot.
No, settlement will be on a different, my lord, footing. It will be on a different platform. There is a procedure. He has only sought for re-allotment. That is why, my lord, this acknowledgement receipt shows, my lord, at page 33, your application for land allotment, and it is numbered as allot, MB allot,
Allotment going, huh?
allotment, my lord, kindly, my lord. And so, like,
No, bless you. I'm still challenging in annexes 2 million, page 16 million. The notice was issued to the company. And subsequently that company has been sealed. And on strength of that notice, my private property also has been sealed on same day.
What notice?
Yes. But this notice was issued to the to company that in Schedule A that I'm stated in page 6 page 6 Schedule L and
Then
I'm
who are you?
I'm the petitioner before lordship for Schedule B land
Schedule B where?
Yes, it's a page 6
Yes.
This is a private property
Huh?
Private property
What is this? There's nothing out there.
Milord.
Schedule B is nothing. Page 17.
No, page not page 6 Page 6
Yes.
Schedule B land. Plot of land measuring 13 lesser 13.7 lesser covered by that number 2138 part number
Then why you are challenging 12?
Milord.
12/8/2024, why you are
Milord.
challenging that?
My submission is that on strength of that notice, they even sealed my private property also, on same date,
Seal.
Seal, This is my private property,
Which property is this? What is it? Page 17.
Page 17 is, some building materials are kept outside the boundary of this private property.
These are not building materials.
Yes, these are,
What do you say? This looks like some broken crockeries.
no, these are building materials,
Huh?
Building material.
Building materials.
So they have sealed your property.
Yes, only on that ground,
You have a trade license.
No, this is company, I am not the company proprietor,
That's the issue, my lord. Lordship, I will hand over your order, my lord. Already the OTC has already approved the,
Oh, you have entered into an agreement with this.
Yes,
already they have approved the court and order was passed.
company already approached the court,
And they were not having any trade license. Trade license was obtained on 16/8/2024 at 1 AM. These facts were not brought on record, my lord, in this petition.
Issue is separate, that's all. And appeal is pending,
Huh?
Company has filed the appeal, that is pending,
Now tell me one thing.
Yes.
What is this agreement, tenancy agreement between you and the company?
Tenancy agreement is, the schedule of property, basically government land allotted to the Muchi Kobrostan, and that land was governed by, some society, and the society entered with me some lease, for 10 years, 12 months. The document I have not annexed, in this case, The Delhi-based company, I try to open up the branch office, and for that, I'm giving a sublet to that company, executing this tenancy agreement.
Now, what has been sealed?
The company has been sealed, and my property sealed,
Show me your lease agreement,
I'm
which
not-
you have entered into
Yes,
with
yes, but
somebody.
I'm not annexing this document here.
Where?
I'm not annexing this document.
You see, Schedule A is 2 kathas of land. From the tenancy agreement, it is seen that you got the land from somebody. And then you wanted to sublet it, a portion thereof.
Yes.
You got 2 kathas of land,
Yes.
and a portion thereof is being given to the company. Okay? Now, what is Schedule A?
The details of schedule, I'm just briefly giving the schedule details, I'm not entering the all details, because I'm not annexing that document, That's why I'm just briefing.
Mr. Counsel, when you approach before this court, don't you think that all the documents are required to be brought on record? Well, how do I help you?
Let us, I may be allowed to file evidence.
What affidavit? Your entire case is without any basis. You are saying, I see page 6.
Yes.
Schedule A. Schedule A belongs to whom? Who is in possession?
Schedule land is basically government land, It was allotted to the Muchi community people, and this community people,
Have leased it to you.
they this land governed by some society, Miller, society involved in here, Miller. And the society given me the lease, Miller, for particular period, Miller.
So again, you subletted that to.
Yes,
to-
with consent of that society, Miller, I just give sublet for 11 months.
How much land?
2 kata, Miller.
So how much land did you take on lease?
2 kata, Miller.
Then already an action has been taken against this Excel. Then how does your requisition is maintainable?
I'm not in the I'm not in this case, Miller, on Schedule L land, Miller. I'm on Schedule B land, Miller.
Where is Schedule B land? You got only 2 kathas of land.
This is the Schedule L land, Miller.
Understood?
Yes.
The tenancy agreement is
Yes.
for 2 kathas of
Yes.
land, wherein it says that you have taken on lease 2 kathas of land.
Yes.
Against that 2 kathas, you gave the 2 kathas to this company.
Company.
So what other land you have? Show me. Where's your land document to show me that you have any other land?
Regarding lease, Miller, I have no other land, Miller.
Then you
But-
don't have any land. Then where is the question of sealing your land?
That's why, Miller, they already done, Miller. The Schedule B land has been done, Miller. This is a private property, Miller.
Understood.
Yes,
Where
sir.
is your private property? Show me that. Show me a document to the effect that you have a private property, which is other than the leased land.
Yes, Miller.
Where?
The document is not annexed, Miller,
Then-
because that matter is sub judice before this court, Miller. And
Sub judice before, there is no matter of sub judice before the court. Is there?
Earlier it is in disposed document.
It has been disposed of that Excel.
the Excel, this, Miller, earlier is not disposed of, Miller.
What is sub judice before this court?
This is regarding Schedule B land, Miller. This is a private property land, Miller.
Sub judice in respect of what?
Miller, this land is, Miller,
Unless, Mr. Counsel, you don't show me you have any right over Schedule B land, why should this court at all interfere? And that too, you are asking this court to set aside the documents which have been issued to Excel.
yes,
Now the Excel filed the requisition, that requisition has been disposed of or
Yes, sir.
dismissed, whatever.
That's why,
Then
Miller, my
why
private property,
should this
they cannot
court-
seal my private property, Miller, without any notice, Miller. They cannot seal my private property.
Show me where is your private
Yes.
property?
I'm not annexing this document,
Then-
Miller. I may be allowed to file affidavit, Miller, regarding that, Miller. Additional affidavit, Miller.
Your tenancy agreement is only for that.
No, I'm not tenancy agreement, Miller.
Then
This is the company, Miller.
you don't have anything. Why Schedule B land? Schedule B land is under where? Schedule A land was allotted to a company. Then where is Schedule B land?
Schedule B land is, Miller,
I have
Will
then
let's,
seen that some broken
Sir,
material has
Sarani,
been
but
carved
what
outside
if
the
it's-
boundary of their not on the public footpath or footpath, thereafter charged with division over phone. An amount of AI in cash as penalty for this. The petitioner refused to pay and they also seized the Schedule B property. It is worth to mention herein that Schedule is a private property.
Injurious, Miller, I'm even, cannot go for the appeal, Miller, because notice is not with me.
Learned counsel appearing on behalf of the petitioner submits that he may be permitted to file an additional affidavit to show as to how the petitioner have any right over the Schedule B land.
Okay, sir.
List the matter, how much time?
2 weeks time, maybe.
Is the matter again on 23rd of September?
Okay.
Very well.
Item 50 to 51, stay vacating.
Okay, we have filed a stay vacating petition of the order dated 6/8/6/2023, by which the election process in Silchar Municipal Corporation could not proceed, Lordship. In fact, the background is that Silchar Municipal Board was upgraded to Silchar Municipal Corporation, and thereafter delimitation was done. Few pockets of Silchar which are incorporated in the municipal corporation area, few villages were aggrieved. They filed objections, it was rejected, and they came before this honorable court, and this honorable court finally said in the interim, considering the fact that there is no clarity as to whether the file relating to the issuance of notification of 28/11/2022 were actually put up before the honorable governor of Assam, till next date of listing, it is provided that the impugn notification dated 28/11/2020 shall not be acted upon.
Where is the order? 28?
Page 20. If Lordship is pleased to take up, read petition 595/2023,
Yes. Which page?
page 20. In the IA. And a notification, if Lordship is pleased to look at. Notification, please,
I page 20.
IA page 20.
20 is the order.
Yes, order. The notification Lordship wants.
Yes.
Yes, that is in the petition. The type copy is at page 131. Annex 13. Whereas proposal was received from Deputy Commissioner Kakshar by letter dated 19/9/2022 for inclusion of 42 wards areas in the proposed Silchar Municipal Corporation. Whereas on the basis of the proposal received from the Deputy Commissioner Kakshar, notification for constitution of Silchar Municipal Corporation was published on 28/9/2022 under subsection 1 of section 3 of the Assam Municipal Corporation Act 2022, and objections were invited from the inhabitants of the respective city, town, panchayat areas under subsection 4 of section 3 of the said notice. Whereas 46 numbers of claims and objections were received from various individuals and organizations to the Deputy Commissioner Kakshar, along with specific observation of the Deputy Commissioner on the claims and objections. Whereas after detailed deliberation and examination of the claims and objections, whereas after detailed deliberation of claims and objections, the Governor of Assam is pleased to dispose of the petitions by rejecting the claims and objections which were found to be devoid of merit. Now, therefore, in exercise of power conferred under subsection 5 of section 3 of the Assam Municipal Corporation Act 2022, the Governor is hereby pleased to constitute the Silchar Municipal Corporation with wards with boundaries marked as Annexure A alongside a map as Annexure B. So they are basically agreed by the process of delimitation. So this order was passed. We have in respect of other 79 municipal boards and corporation lordships, election was completed way back in 2022 itself. Silchar is left out until date lordship because of the pendency of the writ proceedings as well as of this.
What is your, what are you stated in your affidavit? What is the reason?
Reason is that
for
their
rejection?
constitutional mandate is there. No area should remain like that.
Understood. What
yes.
is the reasons for rejection of the claims and objections?
Rejection of the claims and objections.
It will be stated in your affidavit.
In the IA also we have given
Page 23. of
page
the-
23.
the IA one.
Report on the claims and objections reached as proposed Silchar Municipal Corporation. And regarding whether it was placed before the governor, that legal argument will make. President Silchar Town Committee claims and objections regarding demarcation of ward boundaries, population, total area demarcation proposed Silchar. Observations. The petitioner present the claim is extension of proposed area to have provisions of smart city in future. However, on scrutiny, it appears that the claim is not tenable at this stage.
Serial number 3.
And serial number
Item
3 is
three minus serial number 3. Item 5.
the
The
present petition
contention is
there.
that the area is backward and agricultural land. Operation tax will overburden the people. On scrutiny, it appears that their objection is not tenable. We are concerned with 1 and 3.
So far as
The petitioners,
we are concerned about all 5.
all fine.
All 5.
There are 5 petitions.
Secretary, Advocate, Bar Association, Silchar.
My unit, my unit is my lot item serial 3, 13, 15, 21.
21, the petitioner present, their
Yes.
objection is against inclusion of Kanakpur, part 1, as the density of population is low. Paddy field is there and there is a tax burden. On careful examination on facts, it is found that the objection is not tenable at present.
Where? 24.
Page 21, page 25, last one, down below.
Mustafa Ahmed.
Yes.
So today my prayer would be very simple, Lordship. Let them file an objection if they have any, And we pleased to keep the matter for final disposal on next week, subject to lordship's convenience.
I'm here to dispose it now.
Okay.
I don't think.
Tomorrow they will object before the division bench said that no opportunity was given to them.
My lord, Secretary, next week, my lord,
Huh?
subject to your lordship's, my lord.
That is why I keep these matters for stability.
Yeah.
So that I'll dispose it
Then
of.
let the matter be taken up on Thursday, lordship.
Thursday,
If they have
no,
any objection, because that opportunity, if it is not given.
Wait,
we have
when
to
did
get a
they
very
file
good
the
chance.
IA?
We filed it very recently, lord. It is not that 6-9.
6-9.
So 7 days is over.
I do not want to give them any ground for going to the division bench, lordship. Otherwise, the constitutional mandate is very clear
Any
that
day
we have to have,
next week, my
and
lord.
on delimitations, there is hardly the honorable courts would like to enter. When we have delimitations, the Supreme Court refused to enter on identical complaints and objections for the parliament as well as the assembly constituency delimitation. Let it be on Thursday, lordship. At least that opportunity, that ground should not be available to the other side to stall the proceedings again.
Thursday. Thursday. Uh,
Or maybe
19th.
wait,
You are saying about 19th.
no difficulty. I'll do it, lordship, any day before
19th?
this.
Possible?
Possible next Tuesday, if possible, my lord.
No, this Tuesday, tomorrow not possible. Tomorrow not.
Next Tuesday.
Okay. 24th.
Lordship.
Mr. H.R. Chaudhary, Learning Council, Senior Counsel appearing. What business you have?
Resident of that area, included.
So you are in favor of the petition or against the petition? Because tell I conduct.
Favor of the inclusion.
So he is with us. You will have
No,
to
we
say-
dispose it of then. If you want to file your affidavit, you file it. Otherwise, I cannot like you, 2825. On 2825 of 2024. Mr. H.R. Chaudhary, the learned senior counsel, submits that taking that petitioners would like to file a reply to the said affidavit, to the said application seeking vacation, modification, or alteration of the order. This court had made a specific query upon the learned counsel appearing on behalf of the parties as to whether they have filed their affidavits, their pleadings. It has been submitted that the other pleadings are duly complete. Taking into account the above, liberty is given to the petitioners to submit file reply to the IAC number 2825 of 2024. However, this petition, this court, taking into account the above, the order, taking into account the matter in its entirety, puts notice upon both the petitioner and the respondents that on the next date, an attempt shall be made to dispose of the petitions. List this matter again on 24th, 24/11 to 9/2024.
Highly appreciated.
Mr. K.K. Day, the learned counsel. This is an application filed by the applicants who claim to be residents of village Tupakhana Part 1. Part 1 or Part 2? Part 1 and Part 2. The applicants, are in support of the inclusion of village Tupakada Part 1 and Part 2 within the ambit of the sincere municipal corporation. It is the further case of the applicants that they had duly participated in the said process and would like therefore to be included in the incident proceedings. From the materials on record, this court is of the opinion that the petitioners herein would not come within, the applicants herein would not come within the ambit of necessary or proper parties to the incident proceedings. Accordingly, this court is not inclined to include the applicants to the incident petition. However, the applicants herein are permitted to intervene in the instant proceedings as interveners, and they would also be heard at the time of hearing of the instant petition. You are only interveners, no business of this. Because they have no business out here. Because it is between you and them. Because if we include them, means you have rendered me to the post of a district magistrate. So they will only be intervened. I dispose.
So there are other connected matters, all will come together.
Yeah, এটা সেই ৰিপিটিশ্যনখনত অৰ্ডাৰ দিব এটা এই তিনিটা ৰিপিটিশ্যনত এটা অৰ্ডাৰ দিব that let these matters be listed on 24/9/2024 at the top of the list for list so that an attempt can be made to dispose of the petitions. The interim orders passed earlier shall continue till then.
Deeply obliged.
তিনটা রিপিটিশন
Article 11.
So will that matter in with the land acquisition spending in the land belonging to the petitioner, which is taken over by the JMC?
Lordship, we have received an instruction yesterday. The quantum has been quantified and the department has made a request seeking 2 months' time for final. The Lordship would kindly give me 1 week's time. I'll try to expedite this matter at the personal level, Lordship.
Financial sanction and what was to be done as for the last one.
It will be
Yes, Mr. Education, when?
next week, let it come next week, but this paragraph 3, Lord, third paragraph.
Hmm.
Based on the view of Revenue and DM Department, authority of so-and-so has accorded approval on 13/9/2024, placing the proposal before Finance Standing Committee for recommendation of issue of sanction of email so-and-so as per. Lordship may dispose of the matter also.
No. This is a matter which started with non-payment of certain amount. Then I got hold of it. Because how can you keep the more from 1986? Then when I got hold of it, then I found out when you are going for acquisition, they come up with that now the land is being made government by the settlement authorities. Then after
Now-
that, I took up the issue.
What I am trying to, if Lordship is going to the third paragraph and fifth paragraph, in view of above, it is requested to kindly place the above act before the court in the next date of hearing and seek 2 months' time so that a fund can be sanctioned and released forthwith with the financial procedures. So that means a commitment has already come before this honorable court. So what I am trying, either Lordship may keep the matter pending, giving 2 months' time, or if Lordship wants to shorten it also. That can be amended.
I'm asking you, you are the Advocate General, you are appealing.
Certain norms I have to, let it be after 4 weeks, I think I can be able to expedite the matter.
Mr. D. Soikia, the learned Advocate General, appearing
But
on-
that this order may be kept as a part of the record, Lordship. This-
Keeping this matter on record means now we are in MNN. It started from XYZ, ABC, now we are in M. Mr. D.C.K., the learned advocate general, appearing on behalf of the state government, had submitted that a request has been made by the Medical Education and Research Department to that they further 2 months' time would be required so that the fund can be sanctioned and released to the and thereupon released to the petitioners. And in that regard, an instruction dated 14/9/2024 have been placed before this court. The said instruction is kept on record and marked with the letter P. Full stop. Mr. D. Sekia, the learned counsel, advocate general, however, submitted that he is taking up the matter with the office of the chief minister, and there is a likelihood that it shall be done more in a more expeditious manner. So taking into account above, list this matter on 22nd of October, two thousand
Office of the Chief
twenty-four.
Secretary, Lordship. Chief Secretary, that will be better.
Huh?
Chief Secretary, because matter is between finance and medical department.
No, this was earlier submitted that it was in the office of the chief minister. That is what I have recorded.
Everything has been cleared. It has
Okay.
come back. Anyway, I'll take this.
Mr. D. Sekia, the learned counsel submitted that pursuant to the instructions placed on 21/8/2024, the matter has been cleared from the office of the chief minister and now is presently lying in the office of the chief secretary. So he submits that he would take appropriate, he would instruct the officials accordingly for doing the needful. List the matter again on 22nd of October 2024, on which if this court be apprised as to whether this petitioner have been duly disbursed the amount.
In date is fixed.
22nd
20.
October.
27th. Deeply obliged.
But try, Mr. Advocate General, please
Lordship.
finish it.
It's a long pending. In fact, at one point, I called the deputy commissioner, all the officers. They pursued the matter and finally come to this figure, quantum.
No, whatever may be, this needs a closure,
It
finish.
needs a closure.
Because you see, if I dispose it of, again, certain things will stop. Otherwise, I could have disposed it
No, no,
of.
I understand.
Because earlier only I could have disposed at that point of time. When there were 2 lawyers for 2 petitions. Now there is only 1 lawyer for 2 petitioners, yes.
That one. Highly obliged.
Yes, Mr. Fukon, what is this? What's an old matter? Something, somebody died.
The solemn petitioner died in a suspicious condition. One that's why the investigation was
Should not be issued in directing the sir to assign investigation in connection with harassing. What is your stand?
Lordship, last instruction we have received in 2017, Lordship, because I have to have the receiving instruction. Lordship.
Okay, Mr. N. Goswami, the learned counsel appearing on behalf of the state respondent submits that he will take appropriate instruction as to what is the present status of the investigation in connection with Hari Singha, PS case number 66/2016. Pusto, list this matter again on 23rd of October 2024, on which date the learned counsel shall obtain the instructions without fail.
All right.
Yes, what is this, Mr.?
In spite of this order, from the- they have not yet filed any affidavit matter.
Whatever. to immediately pay the adequate compensation to the, for the acquisition of 3 bighas of land out of so and so. What? What did they stand? No, the question is, have you taken the petitioner's land?
From this letter also.
What does he say?
It was, road was constructed with a panchayat and well development.
Huh?
Road was constructed by the panchayat and well development.
Oh, Panchayat and Rural Development Authority is a party to the institution.
Yes.
Huh?
Yes.
Where?
Number two.
They are there. Then they have not come. No, but you are the revenue department. You come up. Have you mentioned who has taken?
Yes, panchayat.
Who is in possession of these 3 bighas of land?
We are in position. We are in.
No, you are not. Pay the adequate compensation to the petitioner for acquisition of 3 bighas of land.
Yes.
Who is in possession?
Now panchayat and rural development has taken over our land.
That is what I am asking. Who is in possession?
Now there is a road.
Mr.
Because
Biswas,
originally our
kindly
land,
come to the point.
originally
Who
our
is in
land.
possession? Who is in possession of the land?
Our land, we are in position of the land.
Then why is the question of damages?
Oh, but they have constructed a road or.
So therefore you cannot be in possession.
Yes. We have
Or are you asking for toll from
now
the road?
been removed from the position.
So therefore you are not in possession. So
Yes.
somebody else is in possession. Okay. Now who is appearing for the panchayat and rural? And you, for whom are you appearing?
My lord, secretary of the town panchayat and president of the Surugati. My lord, they are both the incumbent, my lord, they retired from their services.
Mr. Counsel, this is the secretary. Whether this Panchim Gaon Panchayat or there is there or not. Are these Panchim Gaon Panchayat 13 number Panchim Kurukheti Gaon Panchayat is there or not?
It is in existence.
My lord, I am for the restaurant number 5 is the secretary, my lord, and 6 is the president of 13 number Panchim Surugati Gaon Panchayat.
Mr. Counsel, whether 13 number Panchim Kurukheti Gaon Panchayat is in existence or not, then it is the office of the secretary and the president made. So office of the president cannot retire. Now, what is your stand? Who has filed the affidavit?
My lord,
I will respond number 5 and 6. We are not concerned. Why is the panchayat and rural development not a party? And you are the person. Demarcate the land and find out whether any land of the petitioners are in occupation. Then I'll take it up with the panchayat. The petitioner herein is aggrieved by the inaction on the part of the respondent authorities in taking over the land of the petitioner at measuring 3 bighas covered by DAG number 144 of Pata number 4 of village Agdia, Kothar, Moza Khorukheti in the district of Borpeta and without any due process. Full stop. The matter has been pending since 2017. Until date, there has been no affidavit filed either by the state respondents, either by the district administration or by the Panchayat and Rural Development Department. Full stop. It is further noteworthy to mention that the Panchayat and Rural Development Department has also not been represented. Full stop. Accordingly, this court directs the circle officer. Which one? Circle officer not made a party. Under what it will be? Circle officer what? Mr. Biswas, some improvement is required in these type of petitions when you file. Whom should I direct?
Made the deputy commissioner.
Circle officer has to be made where? Under which revenue circle? Whatever revenue circle. Oh, here somebody has given that.
Yes.
This court therefore directs the circle officer, whatever revenue circle, to submit a report before this court as to whether any part of the land belonging to the petitioner have been acquired or taken over by the respondent authorities, more particularly the respondent number 2, for construction of any road. Full stop. The said report be submitted before this court on the next date positively. List the matter again on 11th of November 2024. Full stop. The instructions so kept submitted by Mr. N. Gusami is kept on record and marked with the letter X. Yes, what is this?
May Lordship, please. Perhaps it's item number 14. I'm on VC, my lord.
I have seen you in the VC. Then tell me what.
Lordship. May Lordship, please. I'm just tell your Lordship the background. We have purchased this tea estate.
So
Yes.
in favor of the respondent number, yeah. To whose land it is?
I'm a purchaser. That is, company had purchased this land, Binod Nagar Tea Estate, by a sale deed. Now, what happened, your Lordship, that after the purchase in 2019-99, we came to know that under the Sealing Act 1956, a land measuring 367 viga, 9 kathas, 2 chata, that were declared to be a surplus. Now, immediately thereafter, when coming to know of this fact, we filed a revision application before the Revenue Department of the state government. The Revenue Department asked for a report on the Deputy Commissioner. By communication by a Deputy Commissioner, we have annexed it. By communication, my lord, the Deputy Commissioner said the 67 viga 9 katha 2 chata, that land was going to be settled in favor of a landless small growers. And the 300 vigas, that land is under our possession and which is under the compact area of the tea plantation. That was the report. Lordship, kindly have a look in Annexure 4, page 28. That is the report of the Deputy Commissioner. So therefore, the land, as your Lordship is aware, that the special cultivation is excluded from the Sealing Surplus, the Land Holding Act 1956, as per section 2, subsection 2A. And also the Lordship is aware that the explanation of the ancillary work to the special cultivation. So therefore, we are entitled to retain the land since this is excluded from the Land Sealing Act also. Now,
How?
It's as per the statute, my lord.
How?
I will show you, Lordship.
Now, how is it possible? Because once the land has been made sealing, there's a notification issued
No.
with terms with
No,
75.
no.
Then
What happened?
means?
My lord, what happened? The special cultivation land is excluded from the Land Holding Act 1956.
Mr. Doctor, whether it is excluded or not, that exercise has already been done in terms with Rule 5.
No, we have filed an application under section 7 of subsection 6, which is pending for disposal, my lord.
No, that is another thing. But have you challenged that?
Yes.
Notification?
Yes.
Where?
Here, we have filed the revision application, which is filed.
You have to challenge it under 7(6).
Yes, absolutely
Then
correct.
what
my
happened?
lord. Then that application, when pending for disposal, the DC has, Your Honor, respondent number 3 has submitted his report saying that the 300 vigas land is exclusively under our possession and it is a tea planted land. Then when the state is about to take a decision, what happened? We are before this honorable court. This 300 vigas of land, out of this 300 vigas, 287 vigas that was proposal was sent or was approved by the land development meeting as SDLC. Settled it in favor of respondent number 7, who is not entitled under the land policy of government of Assam to get the settlement. It is a religious institution that land surplus land cannot be allotted to a religious institution. It is under the statute, my lord. It is under the land policy.
No, as per the fixation of Land Sealing Act, as per section 16, it is to be given to those tenants otherwise 17 permits to give it to land to allot to anybody.
No, no,
Anyway,
Lordship,
we'll take it away too.
no, Lordship, please.
No, understood. Everything
My
is
lord.
understood. But the fact
My
that
lord.
it has already been held, if you are not challenging the declaration, where is the declaration being challenged?
We have filed, this report is in connection with our application filed before the government, the deceased report. The
No,
government has,
once it is sealing surplus means it has already gone to the government.
no,
So
we
under
have
such
filed an,
circumstances, what
we-
is to be done is এখন দিয়কচোন land law.
kindly have a look at subsection 6 of section 7 of
Yes.
the, your
What
lordship
have you
is
done?
aware.
What have
we
you
have
done with that?
appropriately, we have filed an application to exempt this land. Since it's,
Then?
we say, then the government has called for a report from the district commissioner Kachar.
Then
And
what-
according, then the district commissioner of Kachar has asked for a report from the assistant settlement commissioner officer. He has submitted a report, and thereafter the DC has forwarded the report to the deputy secretary to the government of Assam, revenue department. In that report, my lord, in that report, that's
Now, why should this court look into all these things?
no, I'm not on that.
Why should this court? Now, what has
no.
happened to your revision proceedings
Ye-
before them?
That is
Before the court?
pending. That is pending, my lord. That
That
is
is pending.
pending. That is pending. Why
it
I am
has
before
not
this?
been disposed of till now?
That we have filed some representation which is not replied and is pending, my lord. Is at the disposal of the government.
Why is it pending for such a long time?
Yeah, that is absolutely a questionable, absolutely correct, my lord.
Then?
Now, my lord, why we are before this honorable court, during the pendency of my application before the government, we have received a caveat application from the respondent number 5.
Did you file it within 1 year?
That we have, after coming to the knowledge in 1999.
Oh,
we have
no. How do you
No,
do it? From the
no,
date
no,
of
no.
publication of the final
That is,
statement?
that has
From the
not been.
date on which the Assam Sealing Amendment Act
My,
shall come into force, whichever
my
it is.
contention before this, yes, ma'am. My
Huh?
contention, and I am not on that, my lord, before this honorable court. My contention before this honorable court is that this whether it's within time or not, that has not been disposed of by the government with any speaking order. Why I before this honorable court in 2017 we have received a caveat petition from the respondent number 5, wherein it reflected that a plot of land measuring 284 acres, 284 9 kathas of land was allotted, was said to be settled, not approved by the government, in favor of the respondent number 5, my lord, which named as Keshav Smarak Shamiti. Now, our contention is that as per the report of the deputy commissioner, it is clear that this land, this 300 acres of land, is situated within a compact area of the tea estate, and it is full of the plantation. Our contention is only before this honorable court that the settlement or allotment, whatsoever in the name, the deputy commissioner or the subdivisional land advisory committee cannot allot in favor of the respondent number 5. It is against the statutory norms and statutory provision. Section 17, subsection 1, subsection 3 says that it can be only settled in favor of the landless.
No.
Yes,
Where does it
there are
say?
3 categories. Or Lordship,
Where
can you
does
have a
it
look?
say the 17?
17, section 17.
Where does it say to the effect that 17?
yes,
It should
yes.
be done as per the land and revenue regulation.
No, Lordship, there are 3 three things to be Lordship kindly consider.
Mm.
One is the provision under section 17 of Land Holding Act 1956.
Mm.
Second is the land policy and Assam Land Revenue Regulation.
Mm.
Settlement rules 8, 9, and 10.
Mm.
That I will come to. But Lordship will kindly have a look at section 17(1)(3). There are
Yeah.
three categories, my lord.
That's a preference.
Lordship kindly have a look at section 17.
17
there-
says about preference. 17(3) says about preference.
And then, and
It
absolutely,
does
my
not
lord.
preclude the state to give somebody else the land.
No,
You have no
unless,
business.
no,
Unless
the
7(6), any order has not been passed, the 7(5) declaration has been made, and whether this particular plot of land has been made the ceiling, the final statement out there being made that this particular plot of land, the question therefore is whether that land which is being taken out there is have already been declared to be ceiling surplus. If it is ceiling surplus, you have no business out there. You have no business to come before this court. Locus is your issue.
my lord, my application.
Unless you come up with the fact that without the disposal of my revision application.
That will be pleaded in my writ application, my lord.
That
This
is
a
the
primary
only
consider-
case. Mr. Doctor, that is the only case you have. Otherwise, you lose your locus, you have no business to say where the government allots. Then it will amount to a public interest litigation.
No, lordship
The
kindly have a
question
look.
therefore would be as to whether 7(5) declaration being made, that particular plot of land which is now being sought to be allotted to the respondent number 5 is that plot of land which has been already made ceiling surplus or not. If it
Correct,
has
my
been
lord.
made ceiling surplus, then you have no business.
No, I have a two contention, my lord. And my respectful submission before your lordship is that since my application is pending, which is filed under subsection 6 of section 7 before the government, which is not disposed of, this is number one, my lord. And second, my contention is that any allotment without the compliance of the statutory provision as well as the land policy of the
For
government.
that, we will consider at a later point of time when indigenous people come, landless cultivator come. You are not a landless cultivator.
No,
or
I'm not saying
cultivator.
because
You have
my
no business, Mr. Doctor, you have no business to come amongst these. If there is preferential treatment which is to be given to some people, they are the only people who can come before this.
my lord, kindly consider that my contention before the government is that
Yes,
since
what
it
has happened to the revision application?
So I have to take the.
Take instructions only on that. I'm not concerned with others. Only
because
take
they have
as
filed their
instruction. Where is your revision application. This revision application has been filed.
my lord, they have filed their
Pasta order stopping settlement Khatian on the influence. Where?
they have filed their affidavit, my lord. The government has filed their affidavit. Yesterday we have received the copy wherein they have not speaks about this.
What is Annexure 6?
Annexure 6 is, my lord,
The petitioner preferred a revision before this court under so and so, and the government, by admitting the revision, was pleased to call for a report from so and so.
Yes.
That they have submitted a remand. That since passing of the order, of course, a remand report is so and so.
page 27 and 28, my lord, kindly have a look.
Of this. Yes.
Yes.
Lahok. The petitioner herein being aggrieved by the final order passed on in terms with section 7(5) of the Assam fixation of Assam
Ceiling on Land Holding Act, 1956.
Assam fixation of ceiling on land holding act 1956 have filed a revision application before the government, state government, under section 7(6). It is submitted that the said revision was admitted and a report was called for from the collector Kachar Assam, by the letter dated 25/11/1999. It is, however, submitted that Since then, the revision application has been pending. First, the Mr. State government, you revenue, you get. Ms. D. Hazarika, the learned counsel appearing on behalf of the Revenue and Disaster Management Department of the Government of Assam, shall apprise this court on the next day as to what has been decided as to whether the revision application has been disposed of, and if not, why. First of list this matter again on 25th of October 2024.
My lord, get full, my lord.
Made with the lordship. Here one of the very small issues involved. The petitioner purchased a plot of land in the year 99. Thereafter, he realized that my lord, there are some typographical mistake in the sale deed. So he filed a rectification deed, and after rectification deed was allowed, he has filed a application for my lord correction of the records.
Then that application is
Yeah.
pending.
Pending. So my lord.
Yes, why this application is pending?
So this matter has come after a long time, so
It's
previously communication has been sent.
So, it is seen from the instant proceeding. It is seen,
Yeah.
heard Ms.
Yeah.
Ensokia, the
May I
learned
request your
counsel
lordship?
appearing on behalf of the petitioner, and also Mr. N. S. Bolwa appearing on behalf of the district administration of Kamrup Metro. Footstop. The petitioner hearing is aggrieved by the inaction on the part of the respondent authority in not taking steps for disposing of the miss case number 645/2014-15 and miss case number KRC number 161/2015. Mr. S. Bulwar's the learned counsel appearing on behalf of the district administration, Mr. S. Burwa, the learned counsel appearing on behalf of the district administration, is directed to apprise this court on the next day as to what is the present status of the aforementioned two miss cases. List this matter again on 28th of October 2024.
20th, can you wait 2-3 days later? Why not? I'll not be here on 20th.
Not necessary. We will obtain. Let us see what has happened.
So we will dispose of the matter.
Yes, Mr. Padgiri.
Potential non-payment of my lord, solemn and additional compensation, my lord,
What?
as under National Highway Act, my lord. In similar size and division bench of this order, my lord, directed to pay the solemn and
National Highways Act.
National Highway Act, my lord.
This is when? When was it?
It was, my lord, in the year, my lord, 2009, my lord.
2009. You want, what does Tarsem Singh say?
Tarsem Singh, my lord, affirmed the, my lord, passed by the order by the various high courts, my lord, regarding the section 3J of the National Highway Act.
Hmm.
That in the high court, various high court, my lord, declared, my lord, 3J, my lord, unconstitutional, my lord. And subsequently, my lord, approached before the union, approached before the honorable Apex Court, my lord, and Apex Court affirmed the judgment of the High Court, my lord. That therefore, my lord, 3J, my lord, become declaring constitutional, final, my lord.
Now, it was done in the year 2009. What were you doing all this while?
And the, my lord, respondents submitted, my lord, for affidavit stating that, my lord, whether the, my lord, order passed by the Apex Court, my lord, is prospective or retrospective. And that, my lord, petition already pending before the Supreme Court, my lord. As per affidavit, my lord, stated, still pending. And she would, my lord, more appear, my lord, National Highway Authority.
None appears on behalf of the National Highway Authority of India on court. Full Mr. K.R. Padgiri, learned counsel submits that as to whether the judgment of the Supreme Court in the case of Union of India versus Tarsem Singh reported in
2019 9 SCC 304.
304 is prospective or can be applied retrospectively is still pending before the Supreme Court. Accordingly, list this matter again on 18th of November 2024.
Okay.
That's very interesting. Small issue, my lord. Page 31 notice. Unless rule 18(2). They
Huh?
they want to evict us, and lordship, prior to that, lordship, I have
Page?
applied page 31. my lord. That is the interim notice. We have been directed to vacate the premises.
If you have illegally occupied the government lands, therefore you are directed to vacate within the period of 15 days from the within which 18 to. Then,
36 application, my lord, which is pending, my lord.
Huh?
Page 36, the application applying for, my lord, conversion of land to the Maripata, page 36, which is pending. And it has also been protected by the Honorable Court, page 39. Page 39, my lord. There is directions, my lord. Only thing is that, my lord, without disposing of that petition, my attempt was made. She may dispose this matter directly.
yes,
In fact, the petitioner claims that he has submitted a popular petition, which hasn't been traced out. Accordingly, notice has been served
what
upon
the petitioner has submitted?
popular.
What is that Kobula?
Popular for settlement of the gallery.
What
Because
is this Kobula?
he
Application, my lord.
application.
Page
For what?
37, my lord. Page 36.
Kobula
My
survey
application
for
was
what?
pending.
Huh?
It required, my lord, a call.
Application for settlement.
Yes. Because
Settlement.
I am possessing my government land, that's why I have applied for conversion. And since there was a situation, I have been protected by page 39, but my bypassing that notice was issued. Let them take a call, my lord, whatever.
Huh?
Whatever they want to take a decision on my application, reject or accept, my lord, but let them dispose of it.
Now, against this notice, have you submitted your representation before the authority?
Yes.
Where?
That is the part of my petition that contained in my lord page, my lord 41.
This is not a representation.
For renters.
Yes, only copy was furnished, but my application was already pending there earlier, my lord.
Huh?
My application,
Application for settlement is another aspect of the matter.
my lord.
What has happened now, what has happened is this. You have submitted an application for settlement
Yes, my lord.
on 2015.
Yes, my lord.
Then,
Thereafter, my lord, since it was not considered, my lord, the pressure was created. I approached before the honorable court. Now, this honorable court protected me.
this court has, what has happened to the petition?
But that disposed of, my lord, because the motion is
Protecting you how?
my lord, page 40.
Motion is directing the reserve to give due consideration to the said application for settlement, provided that the application be given its due consideration by speaking order within a period of 2 months from the event. It is further worded that during the aforesaid period of 2 months, the respondent shall not take any call. Only for 2 months. That
But they have to take a call on my lord, that application. That was not done, my lord. And bypassing that, my lord, no notice was issued. That's why, my lord, that there must be decision, my lord. Accept or reject, whatever, my lord, let them take a call.
Notice was issued in 2023. So the petitioner could not be traced out. Accordingly, the notice, Jarikara could not serve the notice on the.
what notice for hearing?
Yes.
Then
For
notice
this,
before circle officer, dispute revenue circle.
Yes.
Chalo. So this is also issued by the circle officer. let the petitioner submit a representation within 10 to 15 days from today and give him the hearing and decide.
That would
This
suffice.
court has no business out
Yes.
here.
That is the ultimate thing, man. That-
Or Mr. S. Samaria, the learned counsel appearing on behalf of the petitioner, Mr. S. Burwa appears on behalf of the district administration of Kamrup Metro, and Ms. P.R. Mohanto appears on behalf of the revenue department. The petitioner herein is aggrieved by the issuance of notice under section 18.2, rule 18.2 of the settlement rules dated 4/1/2019, whereby the petitioner has been asked to vacate the land, taking into account that the land wherein the petitioners are, how many petitioners?
Single.
When the petitioner is in occupation, is a government land. Full stop. This court have seen have perused the said full stop. This court have also seen, heard Mr. S. Bulwa, the learned counsel appearing on behalf of the district administration, and have also perused the affidavit so filed by the district commissioner, Kamrup Metro. From the materials on record, as it transpired that the land in question is a government wasteland. The land in question, which is being presently possessed by the petitioner, is a government wasteland. Full stop. It is also seen that the petitioner had submitted an application seeking settlement on 25/6/2015, and the said settlement application is still pending. Full stop. Further to that, the records also show that there is a specific order dated 12/5/2017 passed in WPC number 2788 of 2017, wherein there is a direction upon the authorities concerned to dispose of the said application for settlement dated 25/6/2015 within a period of 2 months, and till such disposal, no coercive action is to be taken insofar as the land measuring 1 katha 10 lechas covered by dark number 484 situated at Betkuchi under Beltola Moza district, Kamrup Metro. Full stop. Full stop. On the basis of the above, no, full stop. This court have duly heard the learned counsels appearing on behalf of the parties and have given its anxious consideration. Full stop. The question as to whether the petitioner has a bona fide claim of right involved in the instant proceedings can be well decided by the circle officer, Dismissal Revenue Circle. It is also pertinent to take note of that as the land in question is a wasteland, and if the petitioner comes within the persons eligible to be settled in terms with the land policy of 2019, the respondent is required to in 19, the petitioner, in the opinion of this court, would have a bona fide claim of right involved. Under such circumstances, this court is of the opinion that the ends of justice will be met if the petitioner is given the liberty to submit a representation within 15 days from today before the circle officer, Dismissal Revenue Circle, in reference to the notice dated 4/1/2019, which has been impugned in the instant proceedings. If such representation is submitted showing that the petitioner has a bona fide claim of right involved, the respondent authorities cannot proceed to summary evict the petitioner unless due procedure is followed. With the above observations and directions, this court therefore disposes of the instant with petition, thereby granting the liberty to the petitioner as stated above. Full stop. Further to that, taking into consideration that there is already an order being passed, that no coercive action order, there is already an order dated 12/5/2017 passed in WPC number 2788/2017. This court observes that no coercive action be taken till the disposal of the said representation wherein liberty has been granted, as well as the application so filed for seeking settlement. Full stop. The petitioner, full stop. Before concluding, this court finds it relevant to take note of the submission made by Mr. S. Burwa that on earlier occasions in the year 2023, steps were taken for serving a notice upon the petitioner for hearing, for passing the speaking order in terms with the order dated 12/5/2017 passed in WPC number 2788/2017. However, the petitioner could not be located, and as such, the notice has returned back. Full stop. Taking into account the above, this court observes and directs that the petitioner herein shall within 15 days from today submit the representation, and on that day, a date to be fixed by the circle officer, the school revenue circle, for fixing the matter for hearing, on which and thereupon the proceedings be proceeded.
One small correction. Let's say this notice has been served in reference to this particular order. This High Court's the pending case, writ petition 363/2019. He has been asked to come with all the documents before the ADC, but because service could not be completed. So this is only with referred to this particular case. Not it.
It has been served.
It could not be served properly, so that we have stated in the affidavit.
No. Has the notice been served or not
No, notice could not be served.
upon him?
Steps.
So therefore, I am giving this.
Yes, but that reference to this particular case, not that writ petition number.
Case of court.
The time limit may for disposal of my representation.
Why?
But after they will keep continuing, again, the new problem will come up. On my representation, after any time may any time, 2 months.
Why do you want that?
But reason is that again, the trouble will come.
No, let him accept the notice and let him place the representation, he might dispose of as per.
Submit your representation. Why I am not fixing a date and time? Because if they go against you, what are you going to do?
Yes.
They may not. I get that they're saying that if it is a case of you have a bona fide claim
Yes,
of
ma'am.
right involved, they cannot
Yes.
exercise the summary jurisdiction. They have to go in as per law.
We were directed to file an I for striking of the respondent number 6 who has expired. We need further time for filing them.
What is the matter about?
The matter is arising out of one OA. Original application before the debts recovery tribunal.
Huh?
Original application before the debts recovery tribunal. Thereby the judgment has already been passed. And I'm also not.
My lord, under OA was
Cite the
filed.
order dated in one dismissing the petitioner's petition as well as the order dismissing the petition number so and so and the eviction. Then what happened? Against the debt recovery tribunal order?
Yes, sir.
Yes.
Yes, sir.
Why?
And actually, the OA was filed against the respondent number 6 and his father, who was the guarantor of the loan. And his father had already expired at that time.
Then why are you not moving the DRT on that?
And they substituted, my lord, purportedly under second schedule of the Income Tax Act, but it cannot be done, my lord. They should have amended the petition.
No, if he had done, why didn't you approach the DRT saying that you have passed an order against the dead person?
We have done that, my lord. They have not listened to us.
What?
It was during the recovery proceeding, my lord.
It is in the recovery proceedings.
Yes, my lord.
Your lordship, they have challenged the RO's order.
Huh?
Recovery officers have.
My lord, there are.
No, why you are not challenging that order? You moved that
At the-
before the DRT.
At the very initial.
Which order
stages,
you are challenging? Otherwise, you'll be bound whether the order was passed during the lifetime of your father.
No, my lord. The OA was filed after the death of the
Father,
father.
and it proceeded ex parte.
Your lordship, today I am also not very much acquainted with the facts of the matter.
Mr. M. Sharma appearing on behalf of the respondent
Two and three, your
submits that he is not, he has not prepared the matter, and as such, the matter stands adjourned to be listed after the vacations.
only for 2 and 3.
Appearing on behalf of the respondent number 2 and 3 submits that he is not prepared. Yes, what is this?
That legal. And the
This is useless. As per this, there is already an amendment in section 3. Circle officer can, nothing survives. There.
Director, my lord, they approve that. My lord, Revenue Board, my lord, kindly see the case.
No, the issue involved is as
the
to whether
order
the
of the
circle
revenue-
officer has the jurisdiction. The appellant is occupying government and they have no patta claim over the appeal is therefore not admitted. Dismissed against this. Then
My lord,
you are
they are-
issuing against the circle officer's order.
Yes,
Then circle officer's notice on the ground that the circle officer did not have the jurisdiction.
at their point of time, my lord, they are.
Now they have.
the
There, at that
amendment
point
has
of
come.
time also they had. Mr. Leho. Heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner and Mr. B.J. Talukdar, the learned counsel appearing on behalf of the respondent. District administration. Full stop. The petitioner herein has approached this court by raising a question as to whether the circle officer Kanpur Revenue Circle had the jurisdiction to issue a notice in terms with section 18, rule 18 of the settlement rules. Mr. B.J. Talukdar, the learned counsel appearing on behalf of the district administration has drawn the attention of this court to rule 3, Roman 1. Roman 2, and submitted that the subdivisional officer is of the rank of the circle officer. The circle officer is of the rank of the subdivisional officer. And as such, the said subdivisional officer, a circle officer, had the jurisdiction. This court also having duly taken note of that the subdivisional officer is and the circle officer are one and the same. One and the same, na?
In the rank of subdivision.
The circle, the subdivision officer is of the rank of the circle officer. Is of the opinion that the circle officer had the jurisdiction to issue the notice. had the authority to issue the notice dated 2018. Accordingly, this court finds no merit in the instant petition, for which the instant petition stands dismissed. It is, however, observed that the petitioner herein would be at liberty to submit representation before the circle officer at the Kanpur Revenue Circle, submitting that it has a bona fide claim of right. They have, how many petitioners? The petitioners have a bona fide claim of right involved in the instant proceedings in respect to the land under their occupation. In such circumstances, if the petitioner approaches the circle officer, Kanpur Revenue Circle shall decide the same in accordance with, and then proceed, and thereafter proceed in accordance.
The notice was issued in the year 2018, and the amendment has come, my lord, in the year 2009. And before amendment, my lord, we filed this request.
Where?
Obliged.
Amendment came when?
2009. New land policy has come, my lord, in the year 2009.
Where? Where is the amendment?
It's not me now, my lord.
No. Amendment came on inserted by notification dated 6th of February 2010. Then
Sorry, my lord.
you don't have the.
That is, my lord, I think new land policy, that is 2009. Obliged, my.
Limited prayer, my lord. Commissioners submitted the representation, my lord, before the settlement officer, my lord, to include their names, my lord, in second.
What representation is that?
My lord, page number 32, my lord.
Huh?
Page number 32. Their names is excluded, my lord, from the third settlement.
What?
Draft third settlement, my lord.
Page no, where is the representation?
My lord, page number 37. Earlier was submitted, and on the basis of that representation, my lord, circle office, settlement officer made an inquiry and found that petitioners are in possession, my lord, but till date not.
Why you are submitting representation? Why you are not filing a miscase? What is this representation business? These are all authorities. Why you not filing a miscase? Once you file a miscase, I don't understand. Once you file a miscase, then they have to pass some order this way or that way. Representation, why will they be bothered? Tell me. And the settlement officer is no longer there.
On the basis of earlier
If
representation.
you have any problem, why you are not approaching the circle officer? For inclusion of exclusion of your name. Who has excluded?
My lord, sir, before the settlement officer, we made the representation before the.
Understood. What is this representation business? Now, whether the settlement operation is going on?
Third resettlement. No, draft. Cheetah, my lord, third resettlement.
When?
That we have mentioned in the representation.
This is of 2018.
My lord, our
Then?
petitioner's name already entered, my lord, in the second settlement, my lord, second arrest patta, my lord.
Then?
But excluded from the third, the draft Cheetah, my lord. Accordingly, my lord, we made representations, settlement officer made inquiry and found that we are in possession, my lord, but not included our name in the third settlement. Subsequently, my lord, we have again submitted the representation, my lord, which is in page number 37, my lord.
Is this matter again on 4th of November 2024, on which date Mr. B.J. Talukdar, the learned counsel appearing on behalf of the district administration of Kachar and Hailakandi, shall apprise this court as to what steps have been taken by the settlement officer Kachar and Hailakandi in as regards the representation so submitted by the petitioner dated
My lord, dated, my lord, 29/5/2018.
2018, and you have sent it by post. You see, these are the problems. Why do you approach this court like this? Do you know whether these have been received?
Yes, my lord, it was sent by post.
Where is
my
your
lord.
signet? It has been received. This is why, if you are interested, why you are not going to the office and giving it? Art Mr. So-and-so, the learned counsel appearing on behalf of the petitioner, Mr. B.J. Talukdar appears on behalf of the district administration as well as the settlement officer of Kachar and Hailakandi. Mr. B.J. Talukdar, the learned counsel, submits that if the petitioner duly submits an application to the settlement officer, there's a settlement operation
Yes,
going
my-
on.
My lord,
Obvious.
third resettlement is going on.
Submits submits an application before the respondent number 3, comma, the said respondent shall duly consider the same. However, sending it by post does not. Sending it by post, it is very difficult to trace out as to whether such, when and how those, whether sending by post cannot be the, Mr. B.J. Talukdar, the learned counsel appearing on behalf of the respondent number 2 and 3 submits that if the petitioner duly submits the application to the office of the settlement officer of the respondent number 3 and the respondent number 3 shall duly consider the same. Mr. So-and-so appearing on behalf of the petitioner submits that the petitioner would duly submit an application before the respondent number 3 and within 30 days from today. It is observed that if such application is filed before the settlement officer within the period above mentioned, the settlement officer, the respondent number 3 shall duly consider the same in accordance with of the petition's terms. By which, what is this sending it by post? You can't go and then you can file the LTR petition.
Lord, this case, we have basically made two prayers. My lord, lordship will come to page 47. My lord, the petitioners are, my lord, Vita owners, my lord. They, under the process of an auction, they got their Vitas, our paying valuable considerations, and my lord made their construction on it. And my lord, selling vegetables and all, these are small businessmen. Now, my lord, will kindly come to page 47. Earlier also they approached, my lord. Page 47.
What are you asking for?
This,
While letters issued by respondent number 3 to the petitioners, Vita holders on so and so, arbitrarily raising the toll charges Vita rent of the petitioner by 3 times the existing amount. And threatening consumer for non-payment. Yes, what was the earlier rate?
well, earlier, page 47, earlier was 30, it is raised to 90, 40, 123 times fall. Now, my lord, will kindly see the next, my lord, page 49. These are the petitioners are the Vita holders, they made their own construction. The Vitas, they got it through a process of an auction. But page 49, the Nutan Bajar, which the municipal themselves constructed, my lord, they are only double. For them, my lord, only double. This is the discrimination. My lord, this honorable court at the initial, my lord, of the date of notice, my lord, has directed us to make payment 100% of the double the rate. But my lord, they received from some of us, but after that they stopped. They are not receiving. This honorable court also in the subsequent order wanted to know the reason. The initial order is in page 25/3/2019. This was the initial order. My lord, we are ready
Who
to
is
pay.
paying for the Hosai?
Hosai, my lord, earlier, Roy appeared. And then there's a subsequent order 24/2022. asking the reasons for not accepting the double the rate. Double the rate, well, we're ready.
What is this? 100 rupees per month?
Yes, Lord.
Huh?
Initially, it was 30, then it raised to 90. Now, by the interim order, we are directed to deposit 60, double the rate. We made deposits, they received from 4 or 5 from us, my lord, and thereafter they stopped. Thereafter, this honorable court on 24, 2022, my lord, wanted to know the reason from them. Why they have not been receiving this. My lord, this is one prayer. Because in 1990 also we approached, my lord, this honorable court has held that since there is no demise premises, we are the owners of the vitas. But the rate was also not reduced there at that point of time. This court therefore did not interfere. Now, my lord, I have a second prayer also. My lord, that is, my lord, at page, my lord, the lordship will come.
You were paying 30 rupees since when?
Since
20 years?
maybe, my lord. We are ready, my lord, that we are not on that. Now they may also increase, my lord, that if they take decision.
Obviously, if this court has stayed it, obviously you have been asking it to pay this amount.
We are ready, my lord. We are some of us they have deposited, they received, but then stop. Double the rate like the other one also we can.
What double the rate? You have paid last time the 20 years back 30 rupees. That was the
No,
rate.
no, not 20. It is raised.
When did you start paying 30 rupees? Tell me.
Well, Lord, earlier we approached in 1990, and that point of time, my lord, it was raised. Page to 60. 1990, it was raised to 60.
From 30 to
Page,
60.
yes, my lord.
And then you challenged it.
Then now, my lord, my lord, they are charging 90 rupees.
Then what is wrong? Now they should make it 100, 180.
No, my lord, lordship, I have the main fear. I know, my lord, this may not be.
What is this wisdom?
Today's-
How can there be a wisdom of this court?
Lordship.
Look into all these things.
No, the lordship is right, but I'm asking, my lord, why the other group is given double, not to, double to us, my lord.
They'll make it double after you start paying to 300. They'll make it 600 double. They won't make it 900. But initially it's very low. It is only in your case it has been made it 3 times. You see, kindly come to page 13 of
Page-
the affidavit or running page 91 of the affidavit.
Affidavit.
All these cases,
Affidavit.
it is not that everywhere. They have done it on the basis of earlier what was happening. Means in your case, 20 years, you have not, there is no enhancement. That is why they did. Like for Nutun Bazar, they have made it double. Nutun Bazar, CH, they have
but
made it
Nutun
double.
Bazar-
Here, number 3, they have not even made it double. They have made it less. 115 became 200. 225 became 350.
My lord, Nutun Bazaar, there is a difference. In our case, this is our own construction, our own vitas. Nutun Bazaar is a building constructed by them. They are tenants there. We are not. The premises, this honorable court has also held, but in 1990, the premises are not demolished property. It is not given to us on rent. We made our own construction. So maybe not it's true that they have a right to ask for vita charges, but why 3 times and 2 times? Why this discrimination? It should be double. Same.
No, no. From when have you been paying this rate? That is what the issue is. That is the most pertinent issue. If you have been paying for the last 2 decades and now they have charged to you this, kindly come to paragraph 6 of the affidavit.
Their affidavit, my lord.
The Vita holders of the old fish market were paying 30, 40, 50, 60, 80, 150, which was very minimum as per market price index and gradually increasing of expenditure in the establishment. Hence, after 20 years in the last board meeting on so-and-so, the board enhanced the rent, but it was also minimum compared to other markets under the Hosai year. We make clear that the last time in 2000, the Hosai enhanced the Vita stores of the man under the Hosai meeting except the old fish market. That is why. What is there? Last time only yours were not there in 2012. Was there any increase of yours? No.
That's right, my lord. I understand, my lord. But my lord,
Now they should increase it by another double. Next time onwards, they should do it double. They
No, my
should
lord.
now do it by double.
my lord, I have another prayer lordship will consider that lordship will kindly see page 44. What by this page 44, what they are asking us to come to my lord, agree to a lease agreement, because how can it be a lease agreement with us, my lord? Because we are with them they can do, Notun Bazaar they can do it, my lord. Because this honorable court earlier also held that we are the owners of the my lord. These they cannot do, my lord. That is why we have a prayer on this, my lord. This honorable my lord will kindly have a look at the last order, 8th page. And they, in their affidavit, also admitted, my lord, that we belong to the construction, we belong to the land. They have not disputed.
Kindly come to the lease agreement at page 44. Number 3.
No, my lord, if they make with the new lessees, there is
No. The question is,
Okay.
what is your authority to remain there?
my lord, for 60 years, by
What is your right?
through a process of an auction, we got it, my lord.
Auction?
Your lordship will kindly see the last order of this one.
No, where is your document?
That
To show that you have got it by auction?
lordship will kindly see page 42. Page 42. It starts at page 35.
Ah.
The municipal board in communication dated so-and-so government had informed that board in its meeting dated so-and-so unanimously decided to bring the Vita situated fish market direct so-and-so. The government in its order approved the action taken so-and-so. The Vitas had been originally auctioned and occupied by the Vita holders, and they have raised their construction thereon from they carried on business for construction. They did not belong
They
to the
were
board.
originally auctioned. Just for example, their particular area may be auctioned very well.
Vita, sir. Your lordship kindly have a look.
Aha, the Vitas will be auctioned. Which are the places?
Yes.
These will be auctioned. So amongst the highest bidder, whoever it is pays or out there, they will be given out there. But do you have a right over the land?
No. The particular plot, small plots, these are called Vitas. And these are auctions. We paid. Everybody has paid. And these paid.
How much did you pay for that Vita?
That I do not remember, my lord. I can.
Then you can't say that.
Page 37, my lord, kindly see.
No.
Page 37. And this is admitted. my
No,
lord,
here
that-
this deed of lease will be. Why are you paying that amount?
Which one, my lord?
The 30 rupees.
30 rupees, my lord, even in private, my lord, land, if I have a business, I am bound to make payment to the municipality, my lord. These are the
Under what provision?
Municipality Act 148, my lord, they can charge beta land and 148 of the Assam Municipality Act.
So
They can
under
charge.
Municipality Act, they will be charging you on what basis? For carrying on the business, a trade license?
Only for business, oh, yes,
Trade license,
yes,
not for the,
not for other, so
but
how?
where is your right to have this land?
Right under the, because we have been, this is not
The
denied by them.
judgment, the judgment cannot be the basis of your right.
My lord,
Whatever is written in the judgment cannot be a basis of your right. Where is your settlement? To the effect that you are given for so many years.
we were given by the town committee. initially.
Understood. Can the town committee for all times to come to transfer the right? No.
My lord, they cannot, my lord, they cannot ask us to enter into a lease agreement now, my lord. How can they ask us to enter into lease agreement? We'll have to agree to it. This is a lease agreement. How can you force us to enter into a lease agreement?
No, understood. You have built it very well. But where does the land come from? Where you have built the vita? Land is whose? That is why in column number 3, it says that you are going to build it, build the vitas. Meaning thereby the vita would be yours. But whatever the land,
But they now say,
no, heard Mr. N. Chaudhary, the learned counsel appearing on behalf of the petitioner. Mr. E.J. Talukdar, learned counsel appeared on behalf of the respondent numbers 2 and 3, and Ms. B. Hadurika appears on behalf of the respondent number 1. The petitioner herein has approached this court challenging the notice dated 1/10/2019 issued by the Circle Officer Bornagar Revenue Circle. It is the case of the petitioner that the petitioner is in possession of a plot of land measuring 1 Katha 5 lechas situated at Tozi number 57 of ward number 5 under Govardhan Moza, Borpeta town in the district of Borpeta since the year 1998. It is the further case of the petitioner that the petitioner have been regularly paying the Tozi revenue and the tax thereof. In addition to that, the petitioner had also applied for patta in the patta have also applied for settlement of the said land in terms with the then existing land policy of 1989. However, while the said settlement operation, said application for settlement have been pending, the impugned notice was issued on 1/10/2019 asking the petitioner to remove the encroachment within 48 hours. It is seen that this court has issued notice on 4/10/2019 and there is an interim order. However, the respondents have have not placed before this court any instruction or for that matter have filed any affidavit in this regard. Be that as it may, this court have also heard the learned counsel appearing on behalf of the parties and given the anxious consideration from a perusal of the materials on record, more particularly the impugned order, the impugned notice dated 1/10/2019, it is seen that the Circle Officer Bornagar Revenue Circle is not sure as to whether the land on which he has issued notice is a railway land or the government land. In this aspect of the matter has got great significance, taking into account that if it is a railway land, the government has the district administration have no authority in as much as if it is a railway land, the provisions of public premises and of unauthorized occupants act 1971 would apply. And in that circumstance, the eviction proceedings would have to be initiated on the basis of that, on the basis of the said act of 1971. However, if it is a government land, it can be, the authority concerned would the circle officer, Bornago Revenue Circle would have the authority to issue a notice. However, if the impugned notice dated 1/10/2019 is taken note of, there is no mention of any dark number or any description of the land in question. Under such circumstances, as the circle officer Bornago Revenue Circle is not clear in respect to its notice as to whether the land is a railway land or a government land, and there is no identification of which land the respondent authority is taking steps, this court is of the opinion that this is a fit case for setting aside the said impugned notice dated 1/10/2019. Accordingly, the impugned notice dated 1/10/2019 is set aside and quashed. Before parting with the record, this court, however, observed that the setting aside of the impugned notice dated 1/9/2019 shall not preclude the circle officer or Bornago Revenue Circle to initiate a fresh process for eviction, provided the land in question is a government land, wherein the question of settlement to the petitioner does not arise.
Item 23.
Withdraw. Mr. HRM, the counsel appearing on behalf of the petitioner submits that he would not like to press the instant petition. Accordingly, the petition stands closed and withdrawn.
24.
Yes, government, what is your instruction? None appears on behalf of the petitioner on call.
Yeah, petitioner received all bills and already cleared.
Ms. S. Burwa, the learned counsel appearing on behalf of the respondent authority submits that the bill of the petitioner have been cleared, have already been paid, and in that regard have placed an instruction dated 16/10/2020 issued by the Deputy Commissioner of Police. The said instruction is kept on record and marked with the letter X. Taking into account the above, the instant petition stands closed.
26.
None appears on behalf of the petitioner on call. Good stop. The petitioner herein is aggrieved by the inaction on the part of the respondent authorities in not issuing the IMFL license to the petitioner pursuant to the communication dated 24/6/2015 issued by IMFL on shop license to the petitioner in favor of the petitioner as per the communication dated 24/6/2015 issued by the Joint Secretary to the Government of Assam Excise Department. This court have duly taken note of the affidavit filed by the respondent number 4 wherein it has been mentioned that the proposed license site is only 150 meters from the national highway, which is also a bar. In addition to that, it has also been mentioned that there is an objection submitted by one Sri Padmo Das on 7/7/2015, and it is under such circumstances the license had not been issued. It seems that the petitioner, in view of the stand which have been taken by the respondents, have lost interest in the instant proceedings. Accordingly, the instant proceedings therefore stands closed for non-prosecution.
Twenty-seven.
Again, this basically the petitioner.
Yes, Mr. Sigdar.
They have, petitioners has lodged a complaint against the private respondent number 3 and 4. That the private respondent has erected a wall occupying the land of the petitioner and also public road.
What is this complaint?
Complaint is that the private respondent number 3 and 4 has erected wall, madam, RCC wall. That a wall has been constructed covering the land of the petitioner as also municipal land. And that allegation is
Municipal land, you have no business.
my lord.
You are concerned only with the petitioner's land.
Yes, my lord. Yes, my lord.
Now, if that be so, why you are not filing a suit?
My lord, we lost a complaint before.
No, what is this? Complaint is okay, but how do you file it?
My lord, there are proceeding, my lord, under CRPC, 133 proceeding for illegal construction. My lord, the deputy commissioner has also filed affidavit admitting that the wall has been constructed without permission.
Remaining 1% of the land of the city. It should be done. These 133, 145 proceedings, these are of urgent nature proceedings. What is this, all this while it is been going on? Where is your right over the land?
My lord, I have a patta land, my lord.
Huh?
We have a patta land, my lord. My lord,
Where is your patta?
my lord, that I have not annexed.
Then where is your right?
My lord, I have lost complaint with the deputy.
No, where is your right? In
Deputy-
which dark number? In which dark number is your right? There is not a single
that
mention of
particular-
your dark number, patta number in your petition.
My lord, I have pursuing that the deputy commissioner can take up
as a proceeding under 133 CRPC, or it can be a proceeding under regulation 23 of the Assam Land and Revenue Regulation.
Why?
Boundary dispute.
Why?
Well, I'm disputing-
You are not asking for demarcation? You're not asking for demarcation,
Yes,
nothing.
I am complaining the illegal construction.
Illegal construction, you are complaining, and if the illegal construction is in your land, it's a case of the filing a suit. If it is your land. If it is a construction by the municipal land, the municipal authority will take it. Who are you to say? The public will speak. There is not a single whisper what land you are the owner. On the other hand, response number 3 and 4 has mutation over those lands.
My lord. My lord, the deputy commissioner filed affidavit. My lord, in paragraph 4 of the affidavit says that the wall has been constructed without permission.
Understood. Without permission, they will do it. Why should this court interfere with all these things? I'm not, the municipality will break it. He is not the petitioner. Let the municipality break it. Without permission, they have the power, they will do it. But that is not the question out here.
My lord, that is the affidavit of the.
The municipality is also not a party here. See? No case. Better file if it is your land. It is not a single mention out here that where is your land? Is there any whisper, which dark number, which patta number?
Not meant.
Why should this court entertain this type of reputations?
Lordship may dispose of the liberty to approve.
You withdraw with liberty.
Yes.
Mr. A.R. Sikdar, the learned counsel appearing on behalf of the petitioner, submits that taking into account the dispute involved herein, the petitioner would be well advised to approach the civil court of competent jurisdiction, seeking appropriate declaration as well as injunction and recovery of possession in respect to and seeking appropriate reliefs. He therefore submits that he would like to withdraw the instant petition and he, however, the learned counsel for the petitioner further submits that in the circumstance that the withdrawal of the instant petition should not preclude the petitioner to avail other remedies which are otherwise available under law. Taking into account the above, the instant petition stands closed on withdrawal. Liberty, however, is given to the petitioner to approach the appropriate to the court of the appropriate civil court if the petitioner is aggrieved by any action on the part of the respondent number 3 and instruction to grant. Yeah. Seeing the name, I asked, where is Mr. M.J. Burua?
My lord, this petitioners category 2 and 28, 29, 30, this is category 1. These are waiting for allotment. This allotment is given, but this space was occupied by some others. That is the issue. That is why mandamus is sought, my lord. So petitioners were prior victims, and in their favor, page 21 and Nectar B, there is an order in 2007 says that page 28.
Mr. M.J. Burua, your matters cannot be taken in days on a non-miscellaneous, on a miscellaneous. This will require a law. Where is the El Potan? Where is this land now?
Land is
in Fancy Bazaar.
Where?
It's a JMC building, the center JMC.
Is it outside, inside, where?
It's in the setback.
Huh?
In the setback of the building.
Setback. El Potan, no.
setback, we are not given allotment in setback, my lord. That is another percentage.
Compound of the building.
Huh?
Compound of the building.
We are in compound.
Compound of the building.
Oh,
Then
compound of that building.
With that, because of that high out 89, there are resolutions to accommodate these persons, everything.
Now, there is another repetition. There are 3-4 repetitions in this time.
Multiple, he files every month.
These are disposed of by your lordship. Already a fish market, that is your lordship given favorable, but they are not waiting. Well, but some shops, 300 shops, they have to allocate, but 30 numbers of are left out, some outsiders over. So they
Mr. We'll have it after vacation in a peaceful mind.
this petitioners, page I think 28, my lord.
since they have cleared it, immediately, so they are waiting, they even paying the rent also, your lordship,
Very well, they are paying, we were running.
not running, we are without business, because.
We'll
this
do
is
one
clear.
thing, we'll have it after vacation on a day, give a date.
My lord, before vacation, my lord.
No, before vacation,
Issue
we
is
should not
nothing,
disturb the
madam.
Puja Bazaar.
Issue
Let
is-
us have it on 29th,
My lord, issue is saying,
29th October.
our,
No, your matter,
Lord,
this
29th.
matter cannot be taken on a miscellaneous day. It is a very complicated matter.
no, my lord, this.
And you get this diagram in which are the petitioners you are
And
appearing.
it starts from 1989 on the day of catching fire, my lord.
My lord, in the evening, I will be in trouble, my lord, then you know what happened today.
Tell him to see the video streaming that
live
this
streaming.
court is confused with the fact that there are so many matters of this. So he says that on a peaceful mind, one has to hear.
In fact, my
I'm
lord,
fixing it on 29th of
29th.
October. These matters on 29th of October 2024, on which date an attempt shall be made to dispose of.
bless you. You want?
You file your affidavit.
And we have annexed the, my lord, report of the, my lord, ARO, that the petitioner is not in possession of certain land, my lord, it is possessed by some other persons. my
Where?
lord. And that the annexer 3, page 45, my lord.
Ah.
Paragraph 7, my lord. Page 33.
Huh?
Paragraph 7, page 33.
Page 33. The extent man submitted a report to the deponent demand to the extent that a land measuring 4 kata 11 is covered by swine so is recorded in the name of Sankar Vidya. Neighbors of the demarcation. In the report, it has been mentioned that people So Bhoben Soikia,
It is possession of the land of the petitioner, my lord.
so he wants what? Demarcation.
I want demarcation, my lord.
And my lord,
Demarcation is done, my lord. We have no any grievance. If the demarcation is done, my lord, then my lord, our problem will be solved, my lord.
But without disturbing the possession, go for demarcation because you issue a demarcation certificate.
My lord, then but annexer 3, page 45, my lord, we have stated that we have went for demarcation, my lord, with the help of the police person. Second paragraph, the copy of the notice also furnished to officer of Harugat Police Station during the field survey, total land of measuring so and so dark number out of the total land measuring 4 kata 11 sir. There was a shortfall of 1 kata, 1 lesser was found. Next paragraph, land covered by so and so dark number so and so, pata number so and so are recorded in the name of Bhoben Soikia. But see, Bhoben Soikia possessed 6 lesser more land in excess over his land. He has also possessed the land measuring 1 kata land less of dark number 458. And the petitioner, my lord, the file a PI, my lord, that this 1 kata 11 lesser, if it is there, then their land will be 1 bigger, then they are entitled for construction of the land. So PI is pending, my lord, there. And in the PI earlier down the application, the honorable court passed, directed the principal secretary to pass an order. Accordingly, both are mutually agreed that the high school section will be transfer, will be shifted to the land for the 15 bighas of land. But the
What will be there?
yeah, they have the petitioner have the 15 bighas of land in other area, my lord, nearby area, and they agreed to shift the high school to the, my lord, to the nearest, my lord, land, my lord. But they constructed the land, so they another PI was filed that is also listed today, my lord.
my lord, that PL is also pending. Earlier PL was disposed of. That is the second round of PL, my lord. Only for that purpose, my lord, if that purpose, 1 katha 11 lesser, if it is their land, then they have only the right over the construction of the school. 1 bigha land of is required for construct, for establishment of school. And that is the shortfall. And that is the main issue, my lord.
Now, understood, but 1 katha 10 lessons, he may
Yes,
have
my-
on
yes, my lord.
papers.
Yes, my lord, that is the.
He has
it is
it on
recorded in his
papers,
name,
1 katha, 1 bigha land.
my lord.
But he does not have in possession of the entire,
1 katha
he
11.
is shot by 1 katha 11 lecture.
My lord.
You're shot by 1 katha 11 lecture.
11.
Okay. But the question is,
Here is the demarcation.
1 katha 9 lecture.
My lord.
Now you demarcate it, show him the land and issue the demarcation certificate, then, but without disturbing the possession
Position
of
of the
any
other
other
man.
party.
Fine,
Who is appearing for Bhupen
Fine.
Soikia?
My lord.
Bhupen Soikia, who is appearing?
He has not made a party, my lord. We cannot demarcation, my lord, we can demarcate it, but regarding the handing over the position and
No,
taking the
no,
advantage. my lord,
don't touch the possession.
yes,
You
my lord, taking
only,
the advantage of that.
no,
my lord,
no,
they are
you
people
only,
to not
you
demolish the
see,
my lord,
there is
position.
a wrong notion.
Yes, my lord, that
To
is
that
the
effect that by way of demarcation,
Demarcation.
one should be given
Dispossess, my lord.
the possession. No,
his position.
possession,
with
not
that observation, my lord,
demarcation. You only issue a demarcation
lord.
certificate
My lord.
showing that this is the area of land who is in possession of so and so and this.
Yes, my lord, yes.
And the
But when
remaining
this
is
was even
in
like this,
petitioner's
my lord,
possession. That's all.
my lord.
I heard Mr. Pulis Roman, the learned counsel appearing on behalf of the petitioner, Mr. J. Sutia, the learned counsel appears on behalf of the KAAC. The instant writ petition has been filed by the petitioner, being aggrieved by the inaction on the part of the respondent authorities in carrying out the demarcation of the land of the petitioner in spite of requests being made. It is seen from the records that an affidavit has been filed by the Joint Secretary, Department of Revenue, Karbi Anglong Autonomous Council. In the said affidavit, it has been mentioned that the land measuring 4 katha 11 lectures covered by dark number 458 or patta number 154 of Hauragat town is recorded in the name of the petitioner. Full stop. It is further stated that pursuant to the applications of file, the land revenue staff of Puloni Revenue Circle went on 5/4/2023 for demarcation of the land after issuance of notice to the pattadas, to the various pattadas. Full stop. During the said proceedings, during the said field survey proceedings, it was found that the total land measuring 3 katha 10 lessa was found in dark number 458 out of the total land measuring 4 katha 11, 1 lessa, na? 11 lessa. 1 or 11?
11 less, my lord.
No, 1 or 11 lessas. Full stop. There was a shortfall of 1 katha 11, 1 katha 1 lessa. Full stop. It was also found that one Sri Bhupen Soikia was possessing land measuring 1 katha 9 lechas of land of dark number 458. Full stop. Mr. J. Sutia, the learned counsels for the KAC submitted that the land covered by dark number Iman 458 recorded in the name of the petitioner could not be demarcated on 5/4/2023 due to the obstruction caused by the neighbors to the land revenue staff to put the boundary pillars. Full stop. The learned counsel further submitted that the question of carrying out the demarcation would not be a problem. However, the question of the delivery of possession is a case, delivery of possession would come within the ambit of the civil courts. First. This court have also taken note of the office memorandum dated, there is an office memorandum, na? Where is that? Demarcation office memorandum? Also take note of the office memorandum.
Actually, it's 21 December 2020.
21 December 2020, wherein it has been office memorandum issued by the government of Assam, Revenue and Disaster Management Department, wherein it has been mentioned that a demarcation certificate is issued only for the purpose of ascertaining the rights of the land and showing the respective boundaries. Under such circumstances, it is also seen, under such circumstances, this court is of the opinion that the demarcation proceedings which have been sought for by the petitioner should be given its logical conclusion by the AAC authority. However, without disturbing the possession of any of the persons who are possessing the land. The same be carried out within 2 months from the date of the instant order.
Petition challenging the curtailing of stoppages inside the Dimrugarh town. Actually, on the last occasion, Lordship had sought some instruction regarding
Oh, that one, stoppage.
issuance of notification.
However, the Learned Council for the Business submits the stoppage at Dibrugarh town is on the basis of the order passed by this court. Well, in the meantime, statements shall apprise this court as to whether there is any compliance to Rule 73(1)A of the Assam Motor Vehicles Act. With reference to the remand to consider John Berry while used as temporary bus stoppage. However, it was not issued as per section remand. Now, what do you want?
We want page 54 and 55 are the impugn orders. It is issued by the DRSC, who is not the also the jurisdictional authority. Jurisdiction authority is at page 55, Lordship. He has passed this order under the dictation of the Deputy Commissioner.
You are challenging which orders?
Page 54 and 55.
Division and demand henceforth stoppage of all types of vehicles and buses and travelers will immediately be shifted from Dibrugarh town except CNG buses. In compliance with the MOU, I asked to be immediately. So your case is that this is not being done in accordance with 73.
73, because there is a specific manner under the statute. They have to do it in consultation with the local authority. And this order, the first order at page 54, the authority is not the jurisdictional authority. Jurisdictional authority is the regional transport officer who has passed the next order under the dictation of page 50, of the Deputy Commissioner. That too without consultation, without following the statutory manner.
What is the statutory mandate?
It's the regional transport authority to prohibit the stoppages. The regional transport authority has to do it in consultation with the local authority.
Local authority means it has to be by the DTO.
Municipality. Municipality. DTO would be the regional transport authority.
Right. The DTO will do it in consultation with the
Regional transport.
DTO is the Regional Transport
Yes.
Authority,
Yes.
RTO.
Yes.
So he will do it in consultation with the local authority.
Yes.
Local authority will be,
To my limited knowledge, it will be the municipality.
why? Hey, see to come up.
Lordship, I have quoted the rules at in one of my additional affidavit. Lordship, will I just at page 67. Lordship. By notification in the official or by
Where?
page 67. Lordship.
Consultation with the local authority having jurisdiction over the area concerned by notification or by erection of traffic sign or board may either consider and prohibit the use. So it may be by way of an official gazette or by erection of a traffic sign.
Yes. Lordship.
It is not required that it has to be in the official gazette.
Yes.
It can be with an erection area, but he has to do so in consultation with the local authority.
Local authority.
The local authority will be, isn't it the deputy commissioner?
Local authority in this term would be the municipality, Lordship, because it's a municipal area. Lordship, in page one, there is another section in the rules. Motor vehicle act, in the act 117, Lordship.
Of
A motor vehicle act, so
act or rules?
act. Going to.
Yes, madam, do it properly. As per rule, to finish it off.
Person may kindly have a look the
Good,
order,
because
page
settlement to
54.
vehicle
Page 54 for a moment
of
of the writ petition.
Yes.
Chairman, this is the main respondent here. I'm appearing for the transport department D2 only. I'm submitting my note, page 54. Lordship, may I read,
Yes,
sir?
yes, I've read it. Tell me.
In pursuance of the decision taken in the meeting of the District Road Safety Committee. Lordship, may kindly note the word District Road Safety Committee, Dibrugarh, held on 22/2023 at 10 AM in the office of the Deputy Commissioner, Dibrugarh. Henceforth, stoppage of all type of buses and traveler will be immediately shifted from Dibrugarh town, except CNG buses to the Muralidhar Jalan bus terminus. Lordship, new bus station.
What is this 73A? Rule or section?
It's rules, my lord.
Rules 73 is rule.
73. What rules?
Of the Assam.
Assam Transport, Assam Motor Vehicle Rules 2003, my lord.
Assam motor vehicle.
Where do I get it?
Lordship, I have
Anyways, then, and what other section you were showing?
117, Lordship. I may also show 215, Lordship, of the motor vehicle act.
117. Parking places and halting, the state government or any authorized authority authorized in this behalf by the state government may in consultation with the local authority having jurisdiction in the area concerned determine the place at which the motor vehicle may stand either indefinitely or for a specified period. Then
Lordship, now a reading of this section also says that it has to be reasoned order. Lordship, no reasons have been cited in the impugn orders.
what reason is required?
Lordship,
Why reasons are required?
Lordship, why they have done that, Lordship, some,
Reasons are required, why? The reason is there on the air, they don't want it out there because of the fact You are causing, this is a case of pollution. They are allowing CNG buses. Go there, have your buses CNG. Electric buses nowadays. Then have it, electric buses.
Lordship, when DLSC is a
Is
separate.
there a stay to this?
No, Lordship. There is no stay because we have constructed the bus terminus outside the town.
Okay, there's no stay.
No stay.
Okay, we'll have it in 2026.
No,
Where it will be.
no, Lordship, also the DLSC.
Better Lordship be directed to file a representation with the deputy commissioner. They will take up with the all stakeholders.
No, Deputy Commissioner, I am not going to give this.
DLSC is a separate statutory authority under 215. Lordship. They have separate functions. Lordship. They are not the jurisdictional authority. There is a statute, there is a statutory manner.
So the Dibrugarh municipality is in your favor of having those buses.
No, Lordship, but
Have you made the Dibrugarh municipality a party?
Oh, my lord.
And you want that to be your local authority?
and Lordship.
No, you want the Dibrugarh municipality to be your savior, and you have not made her a party.
Lordship, only thing we want, we don't want, because there is already an order of this court. There was a meeting, there is an order of this court for these stoppages. In violation of this order, so I have annexed the orders of the court at page 53. There is a final order of the High Court that there is a minutes of meeting and all parties should follow the minutes of the meeting. In the minutes of meeting, there are
So
several.
they cannot change.
Lordship, with the leave of the court, they.
Why? That's a final judgment. Why should a dispose of matter you file a miscase for leave? Circumstances exist that we don't want pollution there. Then we won't allow any vehicles which are having all these things, when it's polluting, diesel vehicles won't be allowed. They are not allowing even the petrol vehicles.
Lordship,
They are only allowing the CNG. They want to have a
only
clear-
one or two stoppages. In the minutes of the meeting, there are.
No,
separate
no,
stoppages.
Dibrugarh roads are very small. Don't do
No,
that.
Lordship, otherwise, how the passengers will, Lordship, stop, get down, Lordship. That is the only concern.
Fantastic. Then what to do with the, tomorrow you will come up with another requisition, shift that particular railway station which is long far away to this inside. There is already, they have a railway station out there, so all the trains should stop here. You may say tomorrow. How will the passengers go there so far off? Now so far off, the roads are much better now. Go there. There's a very beautiful roads on the other side. Inside Dibrugarh, the roads are horrendous. And where will you try, take all these vehicles out there? There is no bus stop. The bus stop is there. Bus stop is on this, have you seen the road? You do one thing. You acquire the land for both the sides of that road and give it to them. They will construct and have your vehicles out. Okay? Give an undertaking to that effect. Have you seen that road where there is that particular that bus station, bus stop? Have you seen it?
No,
Or no?
No,
You have not seen it. Don't do that.
I have
It is absolutely means it is, the road will be something of a size of, I think, it will be smaller than that road, what you call that road which goes, which connects this side of the High Court and Digolipukhuri. There is a small road na, where you park your vehicles. It is smaller than that. And there you want those buses to go?
No, Lordship, only one spot, Lordship, there is.
You acquire your land,
Glass
acquire
corner,
and give it.
it is-
Give an undertaking, file an undertaking that you are going to acquire this land. Goodness. No question of this.
Only one stoppage, Lordship, glass corner, there is I have given some, I have asked for some photo, there is a big space in only one area, Lordship, glass corner. As per my instruction. Only
You
that-
may consider it outside that periphery, outside. Means where you can, beyond that temple, they have this Balaji temple nearby there, give him them somewhere there, some parking.
Outside town area.
Outside town. From there, let the smaller comes.
Near Dibrugarh University also there is.
Dibrugarh University is the other way around. Why will you go by that when you are having the bypass there? Why will you go to the Dibrugarh University? Tell me. Then how do you go inside then? The moment you are going towards Dibrugarh University, you have to go inside and then come out. And there are all small linking roads thereafter to the bypass. So you will be going by the bypass. have a stoppage nearby this, what do you call that, the Balaji temple, and from there you go. There is a good road from there. All these people can go. That is the best part now of Dibrugarh. Other parts of Dibrugarh has become bad because of waterlogging, floods and everything. It's been, although then also I think Guwahati roads are worse. Well, we have it in 2026.
After purification.
Huh?
After purification.
Okay, Miss MD Boras, the learned counsel appearing on behalf of the Transport Department, submit that she will obtain certain instructions in this matter. And as to whether the petitioner's association can be granted any nearby place just outside the vicinity of the Dibrugarh town for having a bus stoppage. To list the matter again on 4th of December 2020.
Deeply obliged.
Find out just outside.
My lord.
Yes, what is this?
My lord. Finally pertains to demarcation, my lord. If my lord comes to it,
Demarcation?
yes, my lord. Demarcation of a land, my lord. Annexure 7 at page number 41, I have annexed the copy of the petition which we filed before the respondent number 3 for demarcating the land. So far the land is concerned, my lord. The total land area is, my lord, about 4 kathas and 1 lechas. From that particular part of land, my lord, 1 katha.
Yes, what is the stand of the government?
That's it. The consent of the co-factor of the land was not given.
Huh?
Consent not given by the co-factor of the land.
Of what? For what? Demarcation. Where is it?
Page 48. And also if a complaint objection was received from Meenakshi Devi, some
Why do you need consent?
notice for demarcation, notice.
He's not asking for partition. Are you asking for partition?
Only for the purpose of demarcation only,
Of the entire land.
of the entire land. So far, our.
What is your
concern-
problem? Why do you need the consent of others? Is it conceived as per that notification?
This notification, can I read?
Please.
One demarcation is allowed by the circle officer. That the billing assistant prepares a notice regarding the demarcation of the proposed land, and it is reserved. It is served to all the co-partners of the concerned duct and partners of the adjacent duct and sent to it to the circle officer for signing. The allotment then visits the SL on the fixed date and demarcate the concerned duct in presence of all the stakeholders. So
Then-
presence is necessary for the
Consent? Why do you request? Somebody may say, I don't have a
presence
consent.
of all the stakeholders.
Understood. They may not. That somebody does not come, so are you not going to demarcate? You are only, why is it necessary? On top it is written in the second paragraph, why the demarcation certificate is required? In that, why is the demarcation certificate required? Number 2, I think paragraph. The demarcation certificate is being issued for the purpose of what?
The demarcation certificates where there is no dispute on title lordship.
No. Why is it issued?
An important service which is provided by the Revenue and Disaster Management Department is the issue on demarcation certificate. This certificate is required to establish the real extent, interest of the land and to establish actual boundary of a particular duct as per cadastral map of the revenue village town. This service can be obtained in the office
So
of the circle
they
officer.
only do that. They'll show you which is the land concern, nothing more than that. As regards the interest in respect to that land, nothing more. You cannot come up and out here and say that, look here, the other pattadas, they don't know. You want this land to be demarcated. You only go and show, but don't disturb anybody's possession, because by way of demarcation, you cannot. It has been a wrong notion. We do one thing, we'll take it up on some other day then.
So this issue which we filed before the
Huh?
respondent number 3, it's been pending since last 2 years. Our
No,
concern
we'll
is
take
for
it
the
up.
demarcation.
Ali ki tarikh? Tomorrow. Ali Thursday. Tuesday. Ali, release the matter on Thursday. Thursday date of the debate at 2 p.m. We'll dispose it on Thursday. Huh? And give me a photocopy of that on office memorandum. Consent or not, that is not the question. Yes, what is this? Affidavit file.
Find that, find that.
What is the stand of the respondents? Yes, your affidavit doesn't seem to be good. File a proper affidavit. You are challenging the rejection.
Not
It seems that the instant petition has been filed by the petitioner challenging the order dated 19/9/2023, whereby the application seeking allotment of the land have been rejected. Also, it is seen that an affidavit has been filed by the respondent number 2. Also, however, the said affidavit is silent in respect to the reasons assigned, the reasons for rejecting the allotment in favor of the petitioner. Also, further to that, in the said affidavit, there is reference to reports of the letter dated 7/9/2022 of the circle officer and the assistant circle officer, Hailakandi Revenue Circle. However, nothing has been enclosed. This court fixes this matter again on 11th of November 2024, directing the district administration to file a more detailed affidavit.
Outline.
Yes, what is this? I have a long count. Oh, he wants time, na? Yes. Because how urgency, no urgency?
Urgency is there, the person is residing in a rented house,
Who?
the petitioner,
Why?
because he undertaken certain repairing and that was stopped method.
By whom?
By the municipal authority.
Why? Who is even for respond number 5?
Your Lordship, I'm appearing for respondent number 5.
Who are you?
Your Lordship, I'm Chibang Krishna, who is the original owner of the plot.
Huh?
Of the plot which is in question, Your Lordship.
Respond number 5 is that person concerned.
Newly impleted, Your Lordship.
You have filed your affidavit.
Lordship, on 9th, we were supposed to file our affidavit in opposition,
Okay.
but his son-in-law died.
to which, and he's a senior citizen, so he's not able to come.
You want to file your affidavit?
Yes, Lordship.
Ms. So and so, they're appearing on behalf of the respondent number 564 for 2 weeks' time to file the affidavit. Please list this matter again. Mr. S. Sahu, the learned counsel for the petition expresses urgency. Mr. Accordingly, list this matter on 30/10/2024. In the meantime, the affidavit be filed by 22nd of October 2024. The petitioner, if so advised, will be at liberty to file the reply. Yes.
The petitioner is agree by the election of the respondent number 5, not demarcating the boundaries of land settled legitimately with the father of the petitioner. Lordship, the petitioner had already deferred on his petition before his honorable court, and that said petition was disposed of with the direction to the respondent number 5 to demarcate the boundaries of the land. However, instead of the land settled with the father of the petitioner, the respondent number 5 demarcated some other parcel.
Our affidavit is ready and sent for vetting, Lordship. Kindly,
As Bolwa appearing on behalf of the respondents, district administration, seeks for 1 week time to filing the affidavit. So list this matter again on 25th of October 2024. In the meantime, the affidavit be filed by 21st of October, on or before 21st of October. So the petitioner thereafter would be at liberty to file the reply. Yes, what is this?
And the affidavit in opposition filed today, my lordship, respondent number 4.
have filed affidavit.
Your file affidavit. It says Bolwa appearing on behalf of the state respondent submits that the affidavit has been filed. So however, the same is not on record. List this matter. What is the matter? Urgency, no urgency? Demarcation.
No, my
Huh? List this matter again on 28th of October 2024. Yes, Mr. Kadi, what is this?
Pertains to my lord, the AGM election of the cooperative society, my lord.
Ah,
Here in this case, my lord, what happened? The petitioner had approached the registrar, my lord,
ah.
and my lord, the page number 56 was the order. Order of
Set
the
aside and squash.
Registrar, my lord.
What are you challenging? Which order?
Now, my lord, the order is of 10-5, page number 88, my lord.
88.
88, my lord.
In pursuance to a petition submitted by Rakib Majumdar and 9 others in the matter of AGM, 2 hearings were held on so and so. Heard the petitioner and the material given the hearing which was used for AGM were also observed that during the poll most of the Yes.
My lord, the kindly produce the earlier order, earlier page 87, my lord, the earlier order of the registrar. 2524, third paragraph, my lord. Had the petitioners and respondents produced the documents submitted by both parties. However, the secretary of the society and both the parties petitioners failed to produce the marked copies of the electoral roll. As such, the allegations regarding the casting of votes by impersonating dead persons could not be ascertained. Therefore, as an interim leader, I so and so, may I direct the secretary to produce the marked copy.
Yes. What affidavit is not filed? Why?
I will file some time again. I will file.
Mr. S.K. Talukdar now has, yeah, now I have realized the difficulty. Mr. S.K. Talukdar, the learned counsel appearing on behalf of the Corporation Department submits that he would like to file an affidavit and 6 for 2 weeks' time in that regard. Who's to list this matter again? What is this matter? What has happened now?
My lord,
Your
now,
election petition was dismissed.
yes,
Okay. List this matter again on 4th of November 2024. The affidavit will be filed by 23rd of October 2024. The petitioner is so advised will be at liberty to file reply. You are who?
Number 8.
Later on, don't say. So, in addition to that, other private respondents will be also at liberty to file the affidavit on or before 23rd of October.
Right.
Nice. Yeah. Yes, what happened? This has become this is a year, huh? This has become infectious, nah? Because he's the lawyer,
Yes, Lauren.
expired.
Expired.
It has been brought to the attention of this court that the petitioner in the instant proceeding have long expired. In that view of the matter, as the instant proceedings cannot be proceeded on the basis of at the instance of a dead person, the instant proceedings stands closed.
In this matter, Counsel Mr. B. Rahman was supposed to appear, but due to his interview in the visa office, he could not come today.
Huh? What is this matter about?
This matter pertains to Lordship issuance of patta of two of the villagers, Lordship, namely.
I think the respondents to issue patta in respect to the land possessing by the petitioner pursuant to allotment of to and so in the district of Kamrup as per law, and to direct the petitioner to take steps for issuance patta in respect of possession by the petitioner. Yes, what is your stand, government? Who died?
The petitioner number 1.
Number 1 is expired.
Okay, petition later, but other petitioners are alive, no? Others are alive. That is not immaterial. You don't make it, it's okay. Others are alive. So, what is your instruction?
Instruction awaited, Lord sir.
Huh?
Instruction awaited, Lord sir.
Why? It's a old matter. 2019. Full stop. The instant petition has been filed by the petitioner seeking allotment of land. Has been filed by the petitioners being agreed by the inaction on the part of the respondent authorities in allotment of the land. The petition was filed in the year 2019 and notice was issued also in the year 2019, but till date, no steps have been, no affidavit has been filed or instructions placed by the state respondents. List this matter or again for admission on 6th of November 2024, on which date Ms. S. Purva appearing on behalf of the district administration, as well as your revenue, Mr. J. Hendig appearing on behalf of the revenue shall apprise this court with as regards the instructions. Shall obtain instruction and shall apprise this court as regards the shall produce the necessary instructions in the matter. Who died?
Petition number 2 for. Petition number 2.
What is the matter about?
Land compensation matter. they contend that they're entitled to zero compensation from the railway, but they have not been able to furnish the joint verification report.
So behold, this is an application filed by the petitioner applicants. This application is filed by whom?
But
By
the
the
legal heir of
applicant, by the
petitioner-
applicant, who is the legal heir of the petitioner number 2. Pusta. It is seen from the materials and record that the petitioner number 2. Who died?
Petition number 2, probably.
Petitioner number 2 expired on. Are you sure? What is the name of the petitioner number 2?
Romo, Lankeshwar Brahmo.
It is seen from the records that the petitioner number 2 had expired on 1/3/2021. Pusto. This court have also taken note of that in the instant proceedings. The pursuant to the death of the petitioner number 2, the right to sue survives. And as such, the cause of action survives. And as such, this court substitutes the applicant herein against the name of the petitioner number 2. Pusto. The counsel appearing on behalf of the petitioner is directed to file a fresh memo of parties before the registry of this court within 7 days. And on the basis of the said memo of parties as well as the memo of parties, as well as the instant order, the registry shall make appropriate amendment, changes to the cost title and also update the same in the CIS. I then disposed. Okay,
I also filed my affidavit.
we filed.
But my presence may
The matter relates to non-compliance of the order dated 19/2022.
We respond number 3.
Lordship, I have one instruction.
Kaveri Bogotuki Sharma, huh?
Lordship, I have one instruction. The Additional District Commissioner Mazuli submitted the report to the Office of the District Commissioner Kamrup, Lordship. And the Office of the District Commissioner Kamrup Metro already sent it to the Principal Secretary. Under the Revenue Department.
Yes, why you are not paying?
It will be paid shortly. I have received the instruction. I am appearing for R1, is the principal secretary. What has happened here, one of the petitioner's husband. They are residents of Majuli. Accident took place in Kamrup. Therefore, my lord, this honorable court directed, because under the scheme, the deputy commissioner concerned has to make an inquiry and then send the proposal to the department.
Yes, she has passed the order, Deputy Commissioner.
Yes, deputy, we have received it only recently, my lord. Now, it has been, my lord, action has now been initiated for releasing the payment. I am told that, my lord, within next 3 weeks, she will get the payment.
Okay, please,
Immediately after-
Mr. Arbopuzari appearing on behalf of the respondent number 1 and 2.
My lord, only one.
1 submits that the respondent number 1 have already received the order passed by the District Commissioner,
Yes, my lord.
Majuli. Kamrup Metro.
Kamrup Metro.
Kamrup Metro dated 23/8/2024.
Office of District Commissioners have to be involved here because of that problem, my lord.
You have
Therefore,
got
sir-
that order, no?
Yes,
Because
yes,
she.
now we have recently received it, my lord.
23/8/2024.
My lord.
And as such, the same, the appropriate action steps are being taken
My lord.
for payment of the dues to the petitioner. First of list this matter again on 28th of October 2024, on which date the council appearing on behalf of the respondent number 1 shall update as to whether the payment has been duly disbursed to the petitioner. First of the instruction the order dated 23/8/2024, it passed by the District Commissioner, Kamrup Metropolitan District is kept on record and marked with the letter X. In view of it is further observed that in view of the communication that they order dated 23/8/2024, this court drops the proceeding against the respondent number 3. And police. You're going to move kaagos mein police also. Yes.
Allot, I, in testament number 9.
Yes, what is this? I for?
I to strike off my name.
Huh?
From the.
I for striking of the name of contempt, respond number 9, Lordship. In this case, Lordship, we filed a objection against that IA today, your Lordship.
I to remove respond number 9. Why?
In original litigation, I was not the party. And I am no involved in this construction work. I am extremely surprised why my name appears.
No. First of all, did they issue notice to you?
Without issuing notice, my lord, directly.
This is an application heard Mr. J. Das, the learned counsel appearing on behalf of the petitioner, and Mr. A. Bhuya appearing on behalf of the respondent number 9.
Now, my lord, 7, my lord.
Huh?
Now 7. Because 2 already been struck up. And now 7.
What is this type of matters, huh?
The respondent is.
This type of what is this? You can't file contempt like this.
2 already been struck up.
What is the order pass? The limits of this. And all these again, balancing is directed that till the next day, that is on 15/3, the status quo with regard to the land involved be maintained. Therefore, said order passed without instructions would, however, be reconsidered on further instruction.
Lordship, the respondent is engaged in the construction of four laning highway project, Lordship. And after the interim order was passed.
Issued a notice under 3A, it is notified that the land covered by particular number would be required for the purpose of construction of the 4 laning, and accordingly, the land was. Hey, your main repetition is where? What has happened to this repetition?
Repetition has been disposed, your Lordship.
Who?
By this honorable court, Lordship.
I have disposed it of. Where is that order?
There is an order of my lord 3/4/2024.
Where is that order?
Because this contempt was filed during the.
Forget about that. These type of matters, there is no sense of it.
3/4/2024, my lord.
Not considering. These type of matters has to be closed. What is this contempt? Your 3D notification have been issued. Have you challenged this 3D? Has that notification on the 3D been struck off?
We had filed this honorable court. I had directed the ADC to give a hearing to the Lordship, and we had filed their application accordingly.
Or what?
For objection against the 3C notice, your Lordship.
So 3D has been set aside.
No, your Lordship.
Then if 3D has not been, because they have gone to 3E.
This contempt proceeding was filed during.
Forget about the contempt. We finish it up. Where is that order? You got that order? Witness? What has happened, Mr. Dotto, as you got 3D? Union of India. Experience. The President, the National Highway Authority is also directed to take note of the standard that the land of the so-and-so was not acquired. Therefore, the authorities and the NHI shall exclude the said part of the land of the prisoner from any person which is envisaged by the NHI unless the said land is covered by notification and it is clarified that the land has noted that except for land covered by DAG number 20, all other lands of which is covered by the notification issued under section 3B by operation of law and which stands vested in it. Therefore, except the land in DAG number 20 or Patta number Imam, in respect of which the order of status quo passed in mayor shall continue till the issuance of the notification, the order of status quo in respect of issuance of stand vacated. Now let us see this. What is your allegation?
Lordship, may directly come to page number 8, your lordship.
Hmm?
Page number 8 of the contempt.
Listed before this court an affidavit for bringing on record the submission of the respondent number 2 on demand despite the aforesaid status quo order dated demand which was further extended till a month. The contender who claims to be the contractor engaged by the respondent number 2 for Foleni came to the lease land of the petitioner and in complete disregard to the aforesaid element. Did not pay any heed to the prayer of the petitioner, and the state contender stated that he has received instructions from the highest office of the state to carry out demand. Violated the order passed by the council to reduce the state of Now, this order, who appeared before the court on that day, 12/3? For respondent number 2, R. Bora for respondent number 2. D. Hazarika for respondent number 4 and 5. 4 and 5. Commissioner, Revenue and Disaster Management, and 5. Secretary to the Government, Revenue and Disaster. Then when did they take the land?
Lordship, the land was
These photographs are in respect to which dag? Has that 3D notification come?
there are several dogs actually because it's a.
Other dogs are gone. Other dogs you have no business of. We are concerned with dag number 20. Has there been a fresh notification?
Prior to disposing.
We are not going to do with all these things. You may ask for whatever may be. These type of matters cannot go on. What about this 20?
20 lessons.
And when did you enter the land, Mr. Bhuya?
I am not involved in this.
Why?
Who will cutting the land? I am a
So
contractor, but I am not working any work on this.
Lordship, basically, it's a joint venture actually, and Anil Das and Seleza Construction, they have been given the tender to do the 4-lane project, Lordship. So Anil Das is directly.
Who entered?
And the contempt number 9, Lordship, Anil Das.
But Anil Das was not a party to the proceedings.
But
then how can you?
But
How can there be an order of violation? And when did they enter?
there are several judgments wherein the.
Nothing doing.
When the
They were not a party to it. How can there be a contempt?
They were informed that there is a status quo order. Despite that, no, they were at the time of violation. They were informed there is a status quo order. Despite that,
When did they violate? When did they enter? Show me.
In para 6, your lordship, page number 10, your lordship.
Where?
No problems ever been made.
Where is that violation? When did they enter? After that order?
No problems.
No,
No case
your
at
lordship,
all.
page number 8 on 16/3/24, your lordship.
Where?
16/3/24.
Page number?
Page number 8, para 4.
Additional comment had issued notice on demand under 3E.
In context,
So and so.
yes,
The
your lordship.
notice for the claim then so and so, indemnity bond and then submit so and so. Then where is it? When did
Para-
they enter?
That, lordship,
Para?
may I read out para 4, your lordship?
Yes.
That on 16/3/24, despite the aforesaid status quo order dated 12/3/24, which was further extended till 21/3/24 by order dated 15/3/24,
by this honorable court, the contender number 9C Anil Das, who claims to be the contractor engaged by the contender number 2, Chairman NHI, for four-laning of National Highway 37, came to the lease land of the petitioner in complete disregard to the appropriate status
Lease
quo
land of the petitioner, where? When, so who violated? Why you are making all the other people a party?
because Lordship, we had given the notice of the status quo.
Let all the respondents appear, all the containers appear. Are everybody appearing? We impose 1 lakh, 1 lakh. In all your favor, you get cost from the petitioner. Huh? Everybody. This is not done. 1 lakh each. You pay. How many persons you have made parties? They are not even with petitioners, you have made party. One. Anurag Jain. My goodness.
The 1 and 2 has been strike off, Lordship.
Obviously, these people will be struck off. And every time there is another person who is getting struck off. It can't happen like this. You have to be more careful. We are imposing the cost on the petitioner. You impose cost upon the council. You, Mr. J. Das, you pay 1 lakh each to all the other people. 3, 4. Anybody paying for 3, 4?
Yeah. 4 I'm happy with. 4, 5, 6, 7, and 8.
4, 5. Everybody. And this will be the advocate fees for all these people.
Lordship, when we receive the
J. Das will pay advocate fees for all these persons, 1 lakh each. You cannot keep on doing this type of things. Somebody else enters. Why you are not making those a party? Why didn't you make them a party in the court? And you are getting an interim order. Now the land has already been given, handed over, possession has been handed over. It is these people who are responsible. Why are you making the entire officials a party? Every time an official has to come before this court that I have nothing to do. What does the Kala has to do? Tell me. And with regard to a possession being taken, what does the Kala have to do? What does the Ministry of Mort Secretary have to do in respect to this violation? He has only issued a notification under section 3 small a, not even capital A. You have made him. There is a responsibility. You are lawyers. You can't do this type of things. We'll have this matter again, not in your presence, because I won't impose the cost upon you. I'll impose the cost upon your senior who has done that. He has done it, no? Yes, Mr. SP Roy is there. We'll have it. This is not the way you have to be careful. You don't come up with this type of matters before me. Mr. You are there. You have filed this? Anil Das. You are the main person. You are the main person against whom the allegations are there. The entire allegation is there, and you are saying that I have nothing to do.
But I am not involved in this. No associated regarding this construction.
The contract was not being awarded to you.
Awarded to my lord, another person, my lord, that is MS O'Neill Shailaja JD.
Not to you.
No. But
Anil Das Shailaja Construction is a joint venture. It's a joint venture, Lordship, wherein Anil Das is also a party.
And O'Neill Shailaja has not been made party in this.
No, who are you?
I am, my lord,
Contract given to whom?
my lord, that is
Huh?
O'Neill Das.
Anil Das is who? You have nothing to do in respect to the contract.
No.
Yes. He says you get me the instruction. No, Kala.
Yes, I'm happy.
Kala. You are Kala. You get me the instruction to whom the contract has been given. We'll have it on. Yeah. And 1 lakh each, huh? To all the advocates. He appears for 3%, 3 lakhs. To Mr. Doctor. Get your money ready. List this matter again on. We'll finish it up. Before vacation, you will get it for puja. Yes. We'll have it on 24th of September 2024. Goodness. At 2 p.m. And Mr. Bhuya, be careful. You also don't make the statement out there that I have nothing to do. If you have anything to do, then see later on.
Yes.
Well, this IA we have filed seeking extension of time.
For what?
Lordship time kindly comes to page 80 in the operative portion of the Lordship's order.
Oh, that one. How
Yes.
do I give it? They have serious objection. Serious objection, na?
We have filed our objection, madam.
They are raising certain things on facts. What has happened, Lordship has given us 42 days,
Because 7 days, 6 weeks.
6 weeks. Huh.
Because 6 weeks is the mandate as per law.
I think it should have been 6 months. It is covered by B.
No.
I amended.
Where you are not represented before the collector, then it
And
is
I am
6.
not on that, my lord. All that I am saying is, my lord, because the earlier set of counsel, he died, my lord, so there was a no communication. It is on that count. My lord. Only, my lord, 7 days time from today, we'll approach the deputy commissioner.
Who died last time? Who was the lawyer?
SN Sharma, my lord.
Oh.
There was a miscommunication, so we couldn't know. My lord.
Yes, Mr. Garodia.
We have filed our objection, my lord.
Understood.
Lordships, the very first thing, my lord, which the petitioner is saying, Lordships, is that after the sale deed, my lord, they have made some development, and this is the reason they are seeking enhanced compensation, my lord.
So that is a matter which will decide by the
That is
authority.
for them to decide.
Yes.
You will very well take up all these objections
Ah.
because that is the question. Once you see after
The notification.
this is done under what provision?
Under the new act, my lord. Old act, sorry, old act.
Under the old act.
Old act.
Under so if it is under the old act, there will be a section 4.
Lordship.
Yes.
So on that day it will stagnate. Means
Lordship.
on that
Yes,
it has to be freeze.
Lordship.
So that is
Yes,
you can't help it. It will be freeze on that date
Yes.
under 4 because if you see then section 23A, the old act.
Old act.
Isn't it?
Lordship.
It is freezed on that day. So any development, if they are doing it up, because then you see section 4. Section 4 says that it is you can't do it once the section 4 notice is issued, you can't do anything to the effect. So it will be freeze on that day. How does it matter? But the fact that there is a person who is dead, and this court had enhanced it, given these have relegated the matter back to the authority concerned, giving them 42 days. Any delay would be only against your thing only. Let him, I'll give 7 days time to.
Only 7 days time from today, my lord.
But we will leave it to Lordships, my lord. But just one point, my lord, before Lordships. What they are saying is, Lordship, my lord, in my most respectful submission, my lord, the learned senior counsel, my lord, Mr. SN Sharma, sir, he expired in November 2022, my lord. And they are saying in their application, my lord, that they have come to know about this in January 2024, my lord.
Yes. Yes.
Therefore, my lord, prima facie Lordships, they have not contacted the council, that the concerned council who was conducting the case for more than a year. There is negligence on their part, and this is the reason, Lordships, they, my lord, on that date, Lordships took up the matter. They were not there. This thing.
This is an I heard Mr. K. N. Chaudhary, the learned counsel appearing on behalf of the petitioner. Mr. P. K. Garudia, the learned counsel appears on behalf of the Airport Authority of India. This is an application filed seeking a procedural review to the order passed by this court dated 2/2024 in WPC number 4271/2012, whereby this court granted this court granted the liberty to the petitioner to file applications before the Deputy Commissioner Kamrup Metro seeking reference, if so agreed with the inadequacy of the compensation, and further directed that the said application be filed within 42 days from the date of the instant order of the said order. It is, however, relevant to take note of that the said order was passed ex parte, was passed in absence of the petitioner's counsel, and it has been brought to the attention of this court that the counsel who was engaged in the matter had expired in the year of in November 2011.
2022.
November 2022. Taking into account the above, this court is of the Mr. K. N. Chaudhary submits that the petitioners came to learn about these orders when?
My lord, in the month of January 24.
It can't be.
No, my lord, order was passed on 2/2/24 on, my lord, in May, in the month of May 24.
In the month
Para
of
5.
May 2024. May 2024. And as such, immediately thereupon had filed the instant application seeking extension of time for filing for submission of for extending the period as provided in the order dated 2/2024. This court, having given an anxious consideration to the matter, is of the opinion that a period of 7 days from today can, of the opinion that in the interest of justice will be met if a period of 10 days from today is given to the petitioner and submit his application before the District Commissioner, Kamrup Metro, in terms with Section 18 of the Land Acquisition Act 1894. It is, however, made clear that in the circumstance there is any enhancement of compensation, the petitioner herein would not be entitled to the compensation interest on that compensation for the period from 2/2024 till the date of filing of the application. During this period, there is no interest. The respondents would be that is okay. There are instances disposed. You'll file whatever it is.
Yeah, please.
Yes, tell me.
We filed this IA for impeachment of the present incumbent, the Director of Land Records and Surveys, as respondent number 4 in the present contempt petition. My lord, we have submitted the representation also on 15/7.
What is the judgment?
The direction of this court was to.
Where's the order?
My lord, in page 56.
Huh?
Page 56, ma'am.
In view of the fact and keeping in view the consent of the party, counsel for the respondent number whatever this court is disposed of with the direction to the commissioner, lower Assam division, Iman to dispose of the petitioner's appeal within a period of 3 months. Now, how can the lower Assam division do it? Lower Assam division is not there. Yes, who can dispose of Mr.
That's what we have.
Arbitration? What can be done this one? I think you need to file an IA or something to the effect. No, no, not here in the writ petition. The writ petition is this. No, contact. How can this be done?
No, they have filed their, petition was filed, that my lord, they had, issues with regarding appointment of Gambura. Now, this my lord, the honorable writ court disposed of the writ petition, relegating the petitioners to my lord to lay an appeal before the authority. At that time, my lord.
No, directing to the commissioner. Now the commissioner's post
Now,
is not there.
Commissioner gone, it was amended, rule was amended, and in place of commissioner, my lord, the principal secretary, GAD was, my lord, granted with that jurisdiction. Now that has also undergone a change. Now the director of land records is the appellate authority. So therefore, whether the petitioners have laid a regular appeal before the director of land records under executive instruction.
That I can't touch it.
Yes.
You, who appears for director of land records?
The director, I will appear.
You appear. So you take it up, whatever petitioner has filed an appeal, take it up out there. And ask the director of land records to do.
So they will have to,
We have filed the.
whether the petitioner have filed a regular appeal before the director.
No, he has filed it before them, na? Keeping in view the consent of the council, the period disposed of direction to the commissioner, Lower Assam Division, Panbaza to dispose of the petitioner's appeal dated. He has already filed an appeal.
So therefore, let the director be included here, my lord. Let the director be.
Why should they make him a culpable? How can you make the director a party now? Because he is not a party at any point of time. He wants to make a party, but how can you make him a contemptuous?
Yes.
They cannot be. It's a contempt proceeding. One has to understand this is not a writ. It's very easy to keep on making, but the fact that how issuance of a contempt notice is not a small thing. It is you do it at the time of as if it's a power of execution. You can punish him. It's a quasi criminal proceedings. Don't take contempt matters in such a casual manner. Because issuance of a contempt notice is a very big thing. It's a different thing. Our courts in some courts issue it in this manner, but therefore I'm very particular when I issue a contempt notice. And if you issue a contempt notice, you have to see, yes, it has to be complied with. If it is not, you take it up. Not for the contempt notice to be issued and tomorrow to drop it, because you can't withdraw the contempt notice. Therefore, a contempt proceeding, you have to be dropped. A contempt petition is not dismissed. It's a contempt proceeding because it is the moment you bring it to the attention, this court will take it up. It is me and the contempt not there. You have no business out there thereafter. Therefore, I am asking, what can be done in this case is to the effect that appeal, the petitioner's appeal, if it is there, let it be taken up by the director of land records on his instruction, and that is he will get an instruction and do it and dispose it on. This is how the thing can be done, because otherwise the only way for you is to file an IA out there and say that that person is no longer, that office is not there, and as such kindly pass certain review this order and make it necessary. This is the only way out. You may say that this court is very technical, but this is how you do it. Because otherwise people may not give any importance to component matter. Hey, it's something like a written notice. No, it's not a written notice. It is exercising a power where, irrespective of you saying, and I don't want to press this material, then also this court has to force it. You do one thing. That petitioner's appeal, which is there, you have filed it on 11/11/2020. You submit it to the director of land records. And the land records, she'll submit it within 15 days. And I fix it after 45 days thereafter, which will be 60 days. Today,
transferred to that office,
Where?
Director of Land Records.
What is the file number? Content cannot rise, no?
Let the petitioner make an inquiry, my lord, and come up with materials.
Hearing dates were given, 3 dates were given, but the director was on leave.
Where?
It was.
Where have you mentioned?
It has not been mentioned here, my lord, but
Huh?
3 days hearing was also.
Get your instructions properly. List this matter again on demand. Give the instruction and get the number. We'll ask the director to finish here. That's all.
Yes.
These matters can't go on like this. You don't impede unnecessarily. No? Because this court may exercise. Although I'm exercise 215, I may exercise 11 and 12. But this court still continues to hold the power under 226. It is the jurisdiction of a court under 226 is never taken away when the High Court is there. Okay, when can you get your instructions? Okay, list this matter again on 25th of September. Get your instruction. What is the number? Then we can ask the Director of Land Records to do. And inform Mr. Borpujari when your matter is there.
I'm obliged.
Yes, what is this? Service complete.
I am taking steps lordship pursuant to the order dated 8/9/2020.
What is this IA business?
By way of justice services.
I disposed of for? Oh, this is pleading. Then what happened? Who is paying for whom?
I am paying for demands or respondent of 4. So we have filed our affidavit today, lordship.
You have filed your?
Affidavit, lordship.
The affidavit is not on record.
Today we have.
Oh, yes, additional affidavit. Okay. You have filed affidavit. And what about the respondent?
I'm for respondent number 3.
And who is paying for the state? Because the money comes from the state, no?
State.
Isn't that your case? Finance? No finance. Okay. List this matter on 29/2024 at 2 p.m. Because the finance people are not there. So Mr. C. Sharma appears on behalf of the respondent number 4 and submitted that an affidavit has already been filed. The registry shall bring on record the same. You?
Number 3 AG. Count and give.
Okay, you have filed affidavit, no?
Just a formal part.
Okay. Mr. B. Sharma appearing on behalf of the respondent number 3 submits that he would make submissions only on the basis of the reports.